application under section 311 CRPC has been rejected. Against that, I have filed this CRPC.
Give the
Tomorrow,
not tomorrow. Tomorrow it's not.
next week, I will get.
We'll see how can we adjust. 311 is not so important. Yes.
Belgium.
Huh?
In the finish.
I don't know 24th what will happen. You give the memo, we'll see. 24th morning you mention, if possible, I'll pick it up. Let it be there. Yes.
Modification of order dated 21/11, madam.
What
In the Para 5th of the order sheet, madam, there is another number. Which is not
Okay,
there.
take it tomorrow.
And one matter that release of case, you also remember, state was that the instruction was posted to 16. 7,57,000 is illegal seizure at the instance of police. It was fixed to 16, but it could not be.
16th date was fixed,
To 16/12.
but it was not listed.
Not.
How it is not listed? Is there a judicial order? Check it up. If there is a judicial order, it has to be listed. Ask for an explanation if it doesn't.
I may pardon to mention, your lordship. Yesterday item list, your lordship, was 79, your lordship. The Vigilance Council has taken 2 times adjournment.
What do you
without
want?
Informing to you. So, your lordship, please.
You have grievance against Business Council,
No,
go and tell them.
I'm not,
Huh.
no, I'm not saying that. May I pray, your lordship, the London Trial Court has fixed to on 5th, your lordship. Your lordship has been pleased to 21st January, your lordship, fixed. So I pray, your lordship, can take.
You have to move an application. Already there is a date. You want preponement that judicial order has to be recalled. So you move an application, I'll take it up. Okay.
High noblesse.
Look, yesterday a matter which I was mentioning with regard to a weekly list matter, my lords is directed to file an application for preponement of the date.
Release the preponement. Okay. On 23rd or 24th. Yes, 24th it is.
Pardon me, madam. The supplemental list item number 103. Several times the matter has been found, but it could not be reached. On last occasion, I made a mention, your lordship said positively taken up, but the matter has not been taken up. My plight is, petitioner is a minor and a student, and he has been falsely implicated in this case.
What are the offences?
Offense 307 to 23 and 24 items. My lord, he has not at the time of occurrence or at the place he was.
But
not-
what have you filed?
I have been to crossing of the affair. And he was-
That I can't decide then.
My lord,
You want an acquittal now?
in charge sheet, only my name is there, but no.
That's right. We'll see. Are you protected? Are you on bail? You are on bail. We'll take it up. Yes.
I beg pardon.
Today I'll take it up. Yes.
I beg pardon, my lord.
Hmm.
Item 53, my lord. Your lordship, before launch, your lordship taken up because today is the surrender date, my lord.
No, sorry.
Today is the surrendering date, my lord.
You are asking for extension.
Yes, my lord.
I'll take up all the matters. I'll take up. Many matters are getting adjourned. I'll take it up.
Before launch, my
Yes.
lord. Before launch.
Let me start now. Yes. If bail matters are there, please give the memo. It will be taken up. Bail matters are urgent matters.
Tired
it
of
will be taken
matter,
up.
tired of matter, but.
You give the bail matters, it will be taken up. Yes, next.
May I be pardoned, my lord?
482, my lord.
May I be pardoned?
Belgium. Belgium.
For convenience order, my lord, challenging the convenience order and the notice was issued, 3 SC Act. I pray to take up this matter, my lord.
Everybody is praying the same thing.
My lord, in fact, we are on.
Nothing new.
41 notice was issued. I was on bail during.
What is the urgency? Oh, pressing need to be listed this side of
Trial
the
court may issue NBW.
May issue, na? When issue, then I'll say. You tell me. You mention it, I'll say it immediately.
May I be
If you-
pardoned, my lord?
You definitely mention. I'll do that. Yes.
May I be pardoned, my lord?
Yes.
My lord, one item 81. May I take an adjournment, my lord, if your lordship will be kind enough to give me an adjournment on item 81?
Are you enjoying interim order?
Yes, my lord, I'm enjoying it.
That way prompted, might have prompted you to take adjournment, it seems.
Oh, my lord, because I'm little.
2016, madam. 2016.
I'm conscious about that, my lord. Any reopening day also it will do, my lord. I just little difficulty on my part today, my lord.
Yes. On the request.
Pardon, your lordship.
Made clear that no further adjournments are given. Yes.
Pardon, your lordship. Item number 5.
But in the list of 17, could not reach. Readings completed. Also, may remember that 25 years matter. Back up. A fact is submitted. I have citation I given, written notes of argument also filed. Tomorrow, so that will be-
Tomorrow, na, madam, tomorrow, madam, if
Not
possible.
Monday.
You give the memo, just check it up, we can adjust it.
Yes.
Decide as we can.
They
We'll
go-
see, we'll see.
During the vacation, also then pass it.
During vacation, how much I'll do? I have already accumulated lot of work,
I know. But they don't teaching actually. 24 वर्ष आएगा.
but I have accumulated enough work.
Yes, that
Yes,
problem.
yes.
Mention item 1 to 8.
Item 5 में लो.
There is any one mentioning in the, I think, online.
No, I'm not mentioning. I'm just waiting. If somebody mentions, then I shall have to object it. I'm just
He
waiting.
is waiting to object some mentioning.
Item 5 में लो.
I'm not
We don't
mentioning it. I'm waiting for item 90 actually.
Okay, it's all
Pilots,
right.
I'm waiting for item.
Nobody is mentioning the item.
No,
Wait,
nobody.
we are asking page wise,
Yeah.
somebody may come, page wise.
Item
Okay,
5
I'm waiting for.
1 minute, page wise we will call, yes.
Item 5 my lord, kindly be taken on after vacation my lord. I have already taken consent from the opposite side council.
It'll go to
Please, item number 7.
March, huh? Yes.
My lord, item 4, my lord, prefer after vacation.
4 also,
My lord.
4 also will go.
May I please, my lord, item number 7.
7
I'm
also.
requesting to the after vacation.
Item 8, my lord. Is the
Why is the fresh matter? Why you people are asking to get it listed and ask for adjournment? I don't know. Fresh matters, 700 matters are pending. No, the other matters all are fresh matters.
Item 100.
And those who are asking for adjournment, at the request, put it in March.
Item 1, I am asking for
Item-
the information.
Item 1,
He's
he is asking for adjournment. Yes.
I am for the opposite party.
Are you opposing?
No, you also let it come after.
March, yes.
1.
Yes.
9 to 22.
Page 2, item 10, my lord.
Hmm.
Passing of the proceeding on the ground of compromise outside the court. The parties to come today. Due to paucity of time and available offences.
What are the offences?
For 24, 68, 7 months.
Then
After vacation immediate, so that both parties.
second week, okay. Yes.
23 to 36.
Yes.
37 to 50.
Well, item number 38, 1 week time for charge sheet and other document file.
38, what do you want?
Charge sheet and other document file. Last time ଆପଣ କହିଥିଲେ କି charge sheet and other document file କରିବା ପାଇଁ 1 week time.
Why have you not filed?
ଆସିନି charge sheet ଆଉ apply କରିଛୁ ଆସିନି.
March,
Sir,
yes.
January.
March.
51 to 58. 59 to 63. 64 to 71.
My lord, item number 66.
66.
Yes, ma'am. On
Yes.
behalf of Mr. D.R. Sundar, it may be taken up.
The request, 66. Okay, March. Yes.
Oblige.
72 to 80.
78, my lord. 78, the petition, unfortunately, the petition number 1 has expired and 2510. I need to substitute it and take necessary
For the
steps.
petitioner submits that the petitioner number 1 in this particular
Expired.
case has expired on
2510,
25
10 to 2024.
2024. He needs to take appropriate step in that regard. Lease the matter on form. Yes.
Interim order to,
Entry mode to continue.
My lords,
interim order to be extended.
Yes. Want to withdraw? Yes.
my lords, item 73.
Mr. Raut Rai seeks to withdraw the. Yes,
My lords,
became infectious. Yes, yes.
my lords, item 73.
70?
73.
73, yes.
Compromise matters, my lords, both party comes to court.
I'll take it 12
Okay,
o'clock.
my lords.
12 o'clock, yes. Yes,
81 to
12 o'clock, please.
My lords.
My lord, 81, I forgot to mention for extension of the interim order. My
Yes,
lord.
interim order is there, it will continue.
My lord, can I know the date? my lord?
Interim order to continue.
The next date, my lord, can I know? my lord? Or-
Next date he'll give.
Yes. Yes, my lord.
90.
My lord, item 88, my lord. There is no interim order,
88.
my lord.
prefer after vacation.
Okay. 88 on request, March. Yes,
91 to 96.
91 to 96. No, yes.
91 mediation date fixed, he doesn't want.
91 of the mediation date 6 to 7 and therefore leave the matter awaiting mediation report after 7. Yes. You said 75 also there is some problem. Huh? 75 inadvertently listed, the matter has already been withdrawn. Yes.
'91 to '96, 97 to 105, 106 to 115, 116 to 120.
That okay. Start.
Item 2.
Yes.
Offense under section 406, 468, 294, 34.
Yes.
My lord, the matter is, sir, that the complainant is arising out of the 1cc number.
What are you seeking here?
Pardon?
What are you seeking? Quashing?
Yes, my lord.
Yes.
My lord, all the petitioners are holding high chairs of Bank of Baroda. The AGM, GM and DGM. Will the complaint in the 1cc was a defaulter loaning, my lord. When the bank started surface action, he lost a false FIR.
Yes.
Filed a 1cc.
Show me the allegations.
My lord,
What is the stage?
my lord, the last occasion, one challenge was dismissed due to non-appearance. And on that time, it was being heard by Honorable Chief Justice, and Honorable Chief Justice had directed me to see what is the stage of the trial. I went myself and verified the records, nothing, only FIR is there, nothing, no investigation, nothing.
No, this is a 1cc case.
No, my lord, that has been sent for investigation.
What is
And
the
the
state?
FIR has been registered.
As
per case 14 minor.
Yeah.
And the allegation is there 3 crores bank holding their charge against the petitions company and 5.84 crores since 14/7/2011. There are allegations, my lord. So what is the stage of the investigation that instruction? Ma'am?
So investigation is going on. Let it be whatever grievances you have. You tell the IO. IO will take into consideration.
I verified the records, it's again.
My lord,
He also
says
says
all the documents you produce for the IO. He will take care.
IO will.
Everything we have submitted from 2020 onwards.
That's right. The IO is not taken. I'll just direct the IO to take into consideration all the document and deal in accordance with law.
My lord.
If you want to file a report under 173 CRPC, that I'll say.
Final report kori.
Yes, yes. At 2020, nothing has happened. What will happen now? Simply issue notice. Let us see. Get the status. Let us see. Mr. Jana, get the status. Okay. Yes. Issue notice. Yes. Next.
Item 3 matter. The lordship will pass on it.
Yes.
Lordship order
21/5.
2024.
Yes.
It will only be adjourned because for the age it has been kept pending. The girl has appeared and filed the affidavit along with his mother, her mother. They are married and child has been took. But now the son is 1 year old also. For that reason, your lordship passed the regime order and told that it will adjourn in February 25. He will attend 18 years. Thereafter, marriage will be.
So then I'll continue the interim order.
Only for that.
On the request of Mr. Vishal, release the matter on such and such the interim order to continue. February last March दे दिया. March दे. ठीक है? March interim order to continue. Because of this judgment, now this judgment has created
yes,
problem.
yes.
Otherwise, it would have been allowed. Yes.
It will be there.
There will be there. Mark the stage itself.
Marriage phase jora kurchha agude if lordship will pass the road that will
You never know. It is a very evolving situation. Something may come. Naturally. See, we are following a reformatory jurisprudence.
some decision
See, something reformatory has to be done.
decision को distinguish करी होगा
asu chutti par date
Should be also part. He is on bail, na?
yes
Then
bail
there is-
and also
Yes. Yes.
Item 6.
challenging the order of convenience under annexed to your lordship. The order dated 27/10 of 2022 in a complaint is your lordship.
Yes.
Your lordship, in two grounds, your lordship. The initial statement of under section 200 of CRPC taken, your lordship, has been contradiction to the complaint petition itself and to each other, your lordship. And on the second ground that, on the very first, the information has been accused in other case where the petitioner number 1 is the informant, your lordship. In a case of 376 and Pukso Act, your lordship.
Yes.
That is under, that has been charge sheeted, and that is under annexed to your lordship. And that FIR and charge sheet is under annexed 4 series, your lordship.
Son of who?
Son of, on that occurrence date, son of the petition number 1, your son of the complainant, your lordship. But the informant in that case is the petition number 1. That is under annexed 4 series, your lordship. And here
Arising out of the same incident.
same day,
Same day.
occurrence date. First FIR is.
Let us see the complaint.
Yes.
What is the complaint?
One, your lordship.
Yes. From the complaint, if any case is made out, I
Yes.
can't help you.
Complaint is under annexed 1.
Yes. What are the allegations?
Allegation ହେଲା ଯେ ମୋ ପୁଅ ଯାଇଥିଲା ତା shop କୁ ଖାଇବା ପାଇଁ ସେ ଦୋକାନ ପାନ ଖାଇବା ପାଇଁ ସେ ଦୋକାନକୁ ବାହାରି ଆସିଲା ତାକୁ ସଦାସତି କଲା when I protested ମତେ ମଧ୍ୟ
page 12 will
ଆଜ୍ଞା ମତେ ମଧ୍ୟ ଖରାପ ବ୍ୟବହାର କଲେ abusing in healthy languages ମୋ ସ୍ୱାମୀ ଯେତେବେଳେ ଆସିଲା ଆମେ protest କଲେ ମୋ ପୁଅକୁ ଗୋଟେ ଶହେ ନେଇକି ପଳେଇଲା Your Lordship, I am going to annex 4 series in the FIR in my case. The date of occurrence.
But see, the allegations are there in the 200 statement also.
But prior to that occurrence.
But those things I can't consider at the cognizance stage.
Your Lordship, there is contradiction in the initial statement.
Can I go into all these things at this stage of cognizance? You may have a fantastic case, but what can I do? There are allegations, complaint is there, 200 statement is there, and case is made out. And you say that if you other things are considered, the case is not made out. Those other things I can't consider at the stage of framing of charge. Cognizance. So that's the issue.
because
You have a good case, but what to do?
This is the
We have to follow the
situation
procedure.
because of my affair. That
I know.
affair has been-
I know. It appears to be, but it appears to be, but the allegations are there against you.
The allegation, there is the allegation, so they have stated that filed FIR, but that has not been referred. Because of my FIR, their FIR has been refused. And he has been arrested.
That I understand it.
That, ଯୋଉ ପୁଅକୁ ସେ କହୁଛନ୍ତି ଏମାନେ ନେଇଗଲେ ବୋଲି, that son has been arrested from there.
This complaint is the counterblast of your FIR. But what can I do, you tell me? What best I can do?
Issue notice, let it be stayed till that.
Stay, there is no question of stay. There is no question of stay. I can only issue notice, see, let us explore the possibility. That's all. Now you can't satisfy. I read it.
because of
I'm fully dissatisfied.
against the offense, not at the offender.
I'll just issue notice. Okay, issue notice. You don't have a case, but let them come. We can pursue it. Yes. Yes.
Item 8. Arose out of a matrimonial dispute, the lordship was placed to send it to the mediation center.
Yes.
Now, both the parties appeared on 7/12, and the next date was reached to 20 tomorrow. Now the parties agreed, so I pray that
24th.
24, not,
22nd it is there. If they settle and park pass, it finished.
but I pray let it come after,
Okay, Okay, vacation product. Mediation still going on. Awaiting mediation report, lease the matter. Entry mode to continue.
And here the petitioner who is a housewife and her bank account has been freezed by the bank manager on the ground up that one economic offence wing Bhubaneswar has directed to seize the account, but nothing, petitioner is not named in the affair and no way connected and no notice has been issued as on date, but total her bank account has been freezed.
Yes,
Your
sir, we
Lordship,
got
got this. His wife housewife,
Hmm.
your lordship will see the transaction and investigation is going on. For that reason,
No, the main accused has already been released on bail. I am not named in the affair, I am not an accused. Even if assuming that any transaction if suspicious, that they can withhold that part, but whole account they have freezed.
Karan Singh and Lallu Singh. Huh?
Yes.
What is her name?
this petitioner Safiana,
Hmm?
Sophie,
Safiana.
Safina.
Safiana,
It says
Safina.
A Safina.
She is how she is related?
There is under investigation. Yes, there is a money, there is a transaction.
Money trail in
Money trail
trace
is
to the account. Trace to the account.
50 lakhs has been transacted in her account. For that reason, I have stated since the huge 40 crore some other odd mailer and investigation is under progress mailer. So that needs for investigation.
Which paragraph?
Last year, last paragraph.
Last
The last.
As many as 125 bank accounts.
Again,
The money is
money trail is there.
traced to those.
But
And what about her account?
2.50 million.
Huh?
2.50. 2,50,000.
Where does
Your
it say?
lordship say, because one copy, I'm sorry, my lord, I'm excused, one copy I have brought for that.
Where does it say?
He has mentioned, my lord, the 2.15 lakhs has been transacted in her account.
Which paragraph you given so much?
I'm reading that paragraph.
Give that paragraph. Yes.
Para 4, my lord, that it has been intimated that the bank by this so and so, that this shared account means this Safiana account, my lord. A petitioner, a Safiana, maintained in Indian Overseas Bank, Koraikola branch, Puducherry, has been frozen. Further, during investigation by letter dated received from manager Indian Overseas Bank, Koraikola branch so and so,
Yeah.
along the details of bank.
Mr. Bali, your account is the fraudulent transaction is traced to your account, so therefore investigation is still going on. You revive your application after investigation.
No, your lordship. What
Yes.
they are saying that some amount, they let them give the details to me.
No, investigation is going on.
Your lordship.
About 14 crores of cryptocurrency fraud has taken place.
No, that
And
is
some amount is traced to your account. Investigation is going on. I can't disrupt at this stage.
No. The Supreme Court and several High Court says the amount, even if assuming that the amount transaction come to my account, that may be
Where? Show me a judgment.
Yes, Bombay High Court, Supreme Court, I will show, let it come.
No, show me right now. I'll pass it over. Pass over.
No,
Show me.
I am with the judgment. I have having the judgment with
Send
me.
it, send it, pass over. Yes, next.
11.
You point out that paragraph, I'll.
And let them serve a copy so that I should go through it, whether it is correct or not. I should verify.
You please, after lunch, you please come. He will give you a copy. Next. Yes.
One order passed by under additional sections of Hon'Ble,
While my prayer for release of my interim release of my victim has been rejected. Under ground.
Have you got the instruction?
No,
Yes. That whether confiscation proceeding in the present case has been initiated or not. Yes, confiscation initiated. What is this trying to say? I don't understand. What is it trying to say?
That is, they have reported before the sessions judge, my lord.
Huh? I simply asked whether confiscation proceeding has been initiated or not. He is what is he saying? Huh? The Honorable got a supreme power and all. What is this?
Your lordship say, I'm sorry, my lord. Your lordship say, keep it day after tomorrow on Monday. I will over telephone.
So let
Monday.
complaint first of all.
Monday.
The Monday record. I just want to know whether confiscation proceeding is there or not. He is giving lecture. 1 minute, I'll hear it Monday. Yes.
Monday.
And 12.
Matter relating to passing of criminal proceeding under the ground of compromise, my lord.
What are the offences?
I am appearing for the opposite party number 2 and 3, my lord.
My lord, initially the FIR was registered under section 363, 366 of IPC, my lord. Therefore, thereafter, my lord, that has been turned to POSCO Act, my lord. 6 of
POSCO. What is the age of this girl?
My lord, the age of the girl is
The 2014 affair, at the time of occurrence, he was 15 years old.
Except FIR, he has not filed anything. I don't know what is happening in the trial.
Offenses also, that should be.
What is happening in the trial? Whether evidence is recorded or not? What kind of petition is this?
14 affair.
I am for opposite partner 2 and
Maybe whatever, but what is happening? 2014 FIR, whether evidence has already been recorded or not, whether the girl is examined or not.
she is married and having a small child, my lord.
You don't understand the technically there is a problem. The girl has already been examined in the court.
my lord, I will take instruction.
No, you withdraw it. This completely frivolous petition. You can't throw papers like this. There should be some standard. 2014 FIR, you are filing for quashing. POXO Act is there. You don't say what happened, whether charge sheet is filed or not. And nothing is filed except FIR. And one line affidavit. We have compromised.
Liberty to.
This is no way. You can't file this kind of petition.
Sorry, man.
Misleading petitions. I don't know. Land Council for the petitioner seek to withdraw this present petition to file a better one with all particulars and relevant documents, with the liberty granted to the petitioner to file a better petition. And the present petition is disposed of. File a better petition, file the charge sheet, in the pleading you write down what has happened. All these things has to be written. 2014 FIR, try to appreciate 2014 FIR. And today, suppose I'll quash it on the ground of compromise. There is nothing in the compromise, one line compromise. If the girl has given the evidence in the court, what will happen? You have not said whether 164 statement is recorded or not. Nothing is there. Better you file. And if you have settled the dispute, file a joint petition. That would be far better.
Here is a case, the victim is married and another man, and petitioner is married to another lady, your lordship, in this case, your lordship.
That's right, I understood it. But see, the problem is
might have not possible.
trial might have proceeded.
Yes, 14 FIR.
2014.
Yes.
And nothing is there on record. Yes.
30.
In my lord, on behalf of Mr. Ekedas, let it pass over.
Pass over, okay.
14.
Team, your lordship, last your lordship directed to obtain whether one could statement on the record of the victim, your lordship. I have already obtained instruction. One statement has already been recorded of the present 14th September 2024, lordship. In one statement, in that category mentioned, lordship, about that percentage.
One 164.
Yes, your lordship.
That I have reproduced. This is now actually the victim files an affidavit. Acha. 164. Yes. 164. Yes.
Wrongly pass over the 13 item. 14 item. 14.
I'm doing some other matter, sir.
No, sir. Inadvertently, someone has passed over the item 13.
But whatever I am doing some other matter, how can you interject like this? I'm reading some other matter you are interjecting. Let us have some decorum of High Court. Yes. Yes, 164, just read it.
Yes. 14 lordship, he requested me to pray for and pass over on behalf of AK Das. Lordship. He is in Lex, lordship. Item 14.
We are doing which matter?
14, your lordship. My learned friend inadvertently 13 is passed over, lordship. 13 matters my learned senior is in this matter, lordship. Therefore,
yeah, I don't understand what is happening. Because you have converted this court to a kacheri, less than a kacheri.
I'm sorry.
If people are there in the fish market or in the court, I don't understand. Yes. Your matter is which one?
13, my lord.
Yes.
So the NI Act case, my lord.
Yes.
The cognizance is taken, I am challenging. The only legal question involved here, my lord, the without condoning the, without giving notice to the other side, the delay has been condoned. And that's the, and the petition, in the petition he said that's not barred by limitation and that's in time. Then he has filed in one application for after 2-3 months, filed one IA.
Condonation of delay.
Condonation of delay for 1 day.
Yes.
And JMFC is, my state has condoned the delay for 2 days. That's without issuing notice to other side.
Is it mandatory?
Yes, my lord. That's the 1995 Supreme Court. That's the covered by. And
Show me. Where is that order? That order is. It's a matter of 2 days.
But he has first submitted in page 24 in the last line. That's in time, and then filed petition for 1 day, and the delay has been condoned for 2 days.
Show me the judgment.
Yes. At the para 16, page 16, I have also mentioned, and that has been also.
So which paragraph is this judgment?
The similar in our with the para 5, my lord.
Para 5. Yes.
I have also mentioned in page 16, my lord. In our view, the High Court was preferred to be justified in holding that the delay in the launching prosecution could not have been condoned without notice to the respondents and behind their back and without recording any reason for condonation of delay. However, having come that the conclusion it would have been appropriate for the High Court without going into the merits of the been remitted back to the trial court with a direction to decide the application of a delay.
No, these are not 138 cases.
No, not 138.
These are
but,
provisional.
yes, but this case is well also.
The statutory schemes are different.
Yes, and also other these cases also.
It's a matter of 2 days delay condoned.
Yes, but
without matter.
My
check amount.
My legal
check amount?
only statement is 30 lakhs, and that's a blank check has been used, and my legal question only to adjudicated here without giving notice to the other side whether can be delay can be condoned or not.
138 case, if 2 days delay is condoned by the court,
not
by
the,
a speaking order,
no,
and notice was mandatory. Show me that.
I'm also only question, my lord, I'm not saying the 1 day or 2 day. That
Yes.
question whether without giving notice to the other side can be
I told
condoned
me
or
that
not.
notice is mandatory. I don't think notice is mandatory.
But I will
Notice is not at all mandatory. So therefore,
delay cannot be condoned, my lord, without notice.
trivial issues.
Delay cannot be condoned in criminal cases also without giving notice. But my lordship saying
Yes,
that
see,
in the 138 cases, my
138
lordship
is always done. The earlier regime was different. Thereafter, the regime has changed. Now,
Yes, ma'am.
delay can be condoned by showing sufficient cause. If there is a 1 day delay,
1 day he has spread and 2 days delay condoned. Yes, ma'am. That's
small things,
yes, ma'am.
in the 138 matter,
Yes, ma'am.
High Court constituted. Petitioner is agreed by the
My lordship,
order.
I'll raise this question there, no?
You raise the question.
Yes.
Petitioner is agreed by the order dated 16/2/2024, whereby the SDGM Parampur, while allowing an application moved by the opposite party for condonation of for delay of for 2 days in filing the complaint, allowed the same. The petitioner is accused in the 1cc case, 1cc case number 415 of
485.
485 of 2023, initiated by the opposite party against him for alleged offences punishable under section 130 NIA. The petitioner submits that although in the complaint the the complainant, opposite party, has mentioned that there is no delay. However, subsequently he moved an application under section 5 of Limitation Act for condonation of delay for 1 day. The learned court below, by the order dated by the impugn order, has condoned the delay of for 2 days. 2 days while allowing the application for the opposite party. Learned counsel for the petitioner submits that the impugn order is a manifestation of a complete non-application of mind, because the petitioner, because the opposite party number 2 in the complaint stated that there is no delay. Subsequently moved application stating that there is a delay of 1 day, whereas the trial court passed the order condoning a delay of 2 days. I am not inclined to entertain this petition at this stage on the tribal issue of condonation of delay of 2 days. Rather, leave this point open for the petitioner to hesitate before the trial court at the appropriate stage. With this observation, the petition is disposed. I left it open.
Yes.
Yes. 15. Yes.
On the petitioner hearing challenging the order of charge on the annexed
You challenge the cognizance order as well as charge order, huh?
Yes, ma'am.
Yes.
Annexed 6, ma'am.
Yes.
Wherein the
Annexure 6.
Yes, ma'am. Page 81.
Charge order, yes.
Wherein I have also filed and discharge petition, madam. Discharging petition as because the offences crime has not made out, as because the gutka coming under the Kotpa Act, madam. I have quoted that provision. Madam, can have a glance to. Yes, madam.
Yes.
Page paragraph 14, page 12, madam.
Page?
Page 12 of the petition. Paragraph 14.
You are reading your application, page 12.
Yes.
Okay.
Para 14.
Para 15.
14, my lord.
Hmm.
Page 12, para 14.
Yes.
The FSSA and FSSA regulation aimed thereunder are applicable only to the food products as defined and standardized under the SAID Act and the regulations. The SAID Act and the regulations made thereunder have no applicability in respect of the trade and commerce, production, supply, distribution of those products which have been defined as tobacco products under 3P of the Code Matter. And these, as per the schedule matter, mentioned in the Act, 3P, these products
Cigarette,
are coming under
cigarette, cigar, cheroot,
bidi, cigarette, tobacco, chewing tobacco.
Yes.
FIR has been lodged, my lord, under.
Let us see the FIR. What are the allegations in the FIR?
Without
charge sheet, come to the charge sheet.
Charge sheet starts from page 40,
Yes.
relevant page is 41.
Read the contents.
During course of investigation, may I read your lordship? During course of investigation, the spot was visited and deposition of witnesses were recorded under 161 CRPC, acceptably in support of a precutable evidence against the accused persons. The adulterated brand of Jardapati chemicals seized exclusively possession of the accused persons manufacturing unit, your lordship. The accused persons were manufacturing adulterated Jardapati by using chemicals and selling the same in market which are noxious for human consumption. The accused persons also not have any trade license, certificate, FSAI, certificate, package, registration, certificate, etc. to run their manufacturing unit.
Yes.
As this, both they were arrested and forwarded to court. The adulterated gutkha packet sent to State Food Testing Laboratory, Convent Square near Ram Mandir, Bhubaneswar by food safety officer and obtained report as restricted for sale due to contents of nicotine. I sent accusation to Tahsildar Tangi Chodwar for obtaining ownership of the plot. Therefore, during course of investigation, the complainant and other witness were examined, the spot were visited, the presence of
Yes,
witness.
I understood it. Yes.
Here,
See, insofar as Kotpa is concerned,
yes, sir.
It is regarding not regarding the manufacturer. It is
But they have mentioned that without food license, I have
those things, those
but
things
these are with me, my lord.
Those things are your defense. You can
no, my
take
lord.
those
These are with me, but they have not given an opportunity to produce that. Subsequently, I have produced, but they have lodged the and my lord, kindly have a glance to page 16 in Godwak Pan Masala IP Limited versus Union of India, 2004 7 SEC. The Honorable Apex Court held that these will not come under the Food Safety Act. I have quoted that provision is also, my lord, I am placing paragraph 77.4.
Yes, I am there.
The state
food
health authority has no power to prohibit the manufacture for sale, storage, sale, or distribution of any article, whether used as an article or adjunct thereto, or not used as food. Such a power can only arise as a result of wider policy decision and emanate from the parliamentary legislation, or at least by exercise of the powers by the central government by framing rules under section 23 of the Act. 77. The provisions of the Cigarettes and other tobacco products, Prohibition of Advertisement and Regulation of Trade, Commerce and Production, Supply and Distribution Act 2003 are directly in conflict with the provisions of the section 7(4) of the Prevention of Food Adulteration Act.
The order to take so and so, passed by so and so, first paragraph and counsel for the petitioner specifically contended that as per the allegation in the charge sheet, the petitioner ought not to have prosecuted for the offences punishable under Food Safety and Standard Act. Rather, on the only offence that perhaps could have been made out is against could have been made out could have been made out is under what is that, under which act we have said, under FSS.
No, Kotpa Act under
Kotpa Acts, Kotpa, pura likhi do Kotpa. Court part. He has relied upon judgment for the Honorable Supreme Court in reported in 2004 7 SCC 68 in Godavat Pan Masala IP Limited versus Union of India. He emphasized the following paragraph, page 17 of the petition, following paragraph. Issue notice, following paragraph means 77.5 and 70.77.6. Relying upon the aforementioned judgment, legal counsel for the petitioner submits that the Code Act being a special statute, if offense is alleged, the same act ought to have been invoked instead of invoking food safety standard. Offenses under food safety standard. Issue notice to opposite party, written. So, in the meantime, petitioner may move application before the trial court for seeking adjournment. Yes. Yes, next. Next.
16. There is a case where the petitioner was in custody and the date was fixed for trial. And on the relevant time, the date was fixed to 31st August 2024. Madam, see Parnature 1.
Yes.
There were the previous advocate who has been engaged by the present petitioner was found absent, and also he filed application that memo that not to conduct the case matter. Accordingly, the High Court on the same day has entrusted the case to one legal aid counsel. And the legal at the relevant time when it was entrusted, on the same day, the legal aid counsel, without having any paper, that I mean to say police paper supplied by the concerned court, because it's my lord knows 207 is clear, unless and until the paper, the charge sheet and containing other paper, police paper will supply to the concerned advocate, there will be no trial, because by the process the accused will not be in a position to know what is the material against him. So no copy was supplied to him, and directly the 3%.
The evidence says, why are you talking about 207? Evidence is going on.
Evidence is not. My case is something different, my lord. The case was posted to trial. On the same day, the previous advocate has filed a memo that I do not want to conduct the case of the person.
Right.
The High Court has given entrusted the case to the state council.
Yes.
The state council without
where will I get those things?
Same
day.
Annexure 1. Madam, see.
Yes.
I am reading, madam. There is the 31st 8 2024, madam.
Yes.
The accused is produced custody. The advocate for the accused files no instruction memo. Being asked the accused submits that he has got no means to engage a lawyer, hence LADC.
Yes.
Defense counsel such engaged to conduct the case on behalf of the accused. The learned special PP is present, and trial of the case is resumed. Schedule 1 victim such and such, Schedule 2 such and such, Schedule 3 such and such were examined.
Okay, so you want recall of this?
I can. Good dinner and that was rape case. 2, 3 victim, mother and father of the victim. They have already been examined, cross-examined. That thereafter,
no, what he says is.
Yes, I am going to that order.
The same day the lawyer gone, another lawyer appointed, and the same day examined.
Much before that,
they were cross-examined, not examined.
Yes, I do consider to give a.
But where is your application? Let us see. What do you want from them?
My prayer is, I may be allowed to cross-examine.
But where is your application? 311
application. No, I have challenged this order, my lord, because the High Court can appreciate. I do consider the High Court has a very good double intention that if nobody will be given without being repeated.
No, if I'll set aside, what will happen?
I'll get a scope, but Madam, I observe that only. Madam, observe that
without moving 311 application, I am giving a liberty. I'll record it, give a liberty.
Yes, Madam.
Because I can't set aside.
Yes,
if set aside, then everything goes.
No, that also meet the purpose. No, my humble submission, but the court should.
I understand it. Suppose I quash it, what will be the consequence?
Malad quashes malad. The same thing, malad.
Not same thing. The evidence also goes.
Yes. No.
Whatever evidence comes.
No.
The evidence recorded the proceeding.
Malad.
and evidence.
My lord.
Both are taken done
There,
same
it is
day.
there, it is there, it is
If
there.
I take out the proceeding from the record, the evidence also goes.
My humble submission, in such a case, again the three person will come, victim, father, and the mother. The
And
person.
you, I'll tell you, you only will argue this thing. There in trial court.
My
The
lord.
High Court has quashed the proceeding. So this evidence is emanating from that proceeding. So therefore, you throw away.
No.
You will argue that.
I mean, how can it? But
You will argue, I know.
one more
You will argue this point.
My one more submission, Lordship, if 31st, 8, 24,
I'll just record this thing and allow you to move application under 311.
yes.
That's all.
ଯଦି ତାଙ୍କର police paper ନଥିଲା ସେ ଯାଇନଥିଲେ ସେ କାହିଁକି ସେଦିନ ତାଙ୍କ 2, 3 କି examine କରୁଥିଲେ Lordship? There no required for.
But he has a grievance and that is a genuine grievance. Genuine.
That's right, you know.
I'll record that and I allow you to file a 311 on that ground right now. Petitioner is agreed by the order dated 31/8/2024, 24 passed by additional sessions judge, special judge under POCSO Act, Sambalpur. Mr. Chand contended that on 31/8/2024, the lawyer who was representing him has withdrawn himself as the petitioner could not afford him. Therefore, the trial court has rightly appointed a defense lawyer,
legal aid counsel,
LADC, defense lawyer, LADC,
legal aid
counsel to represent the petitioner. Ideally, the trial court should have afforded opportunity to the said newly appointed legal aid counsel to prepare the case. However, instead of that, the trial court proceeded to record evidence of PW1.
1, 2, 3,
PW1, 2, and 3. PW
on the same day.
Be that as it may, the defense counsel and made all efforts to cross-examine the witnesses. Mr. Chand submits that without the assistance of the adequate paper being supplied to the defense counsel, he could not conduct the cross-examination in proper perspective, as a result of which vital questions were left to be put to the witness. In that premises, the Mr. Chand submits that the proceeding dated 31/8/2024 may be quashed. I am not in agreement with Mr. Chand, particularly because the petitioner has not moved any application under section 311 CRPC for recalling these witnesses. The proper course would have been to move appropriate application for the trial court. Therefore, although I am not inclined to entertain this petition, however, liberty is granted to the petitioner to move appropriate application to the trial court for the state relief. With these observations, the petition is disposed. Yes.
Item 17, Lordship. The petitioner in this petition praying to quash the entire proceeding on the ground of amicable settlement and solemnization of marriage between the petitioner and the informant victim.
What are the allegations? 493.
No, earlier it was 493/506. Later on turned to
bring them.
Lordship, kindly
tomorrow.
On last occasion, tomorrow. Lordship. Let it be Monday.
Okay, Monday. I'll just simply adjourn it.
Lordship.
Come with the affidavit and all.
Lordship.
Okay, and bring them.
Okay.
Bring 2 affidavits.
Yes.
You may please, your Lordship. Lordship.
Yes, madam.
Yes, Lordship, I have the instructions to, and I have already entered applications to Wakalatnama. And for the informant, Lordship, make a fixed date. We will appear.
Okay, Monday I am fixing it, and bring your client also. Okay, let your client also appear. So and so entered appearance. What is your name? Pradhan. Subhashri Pradhan.
Subhashri.
Subhashri Pradhan, under counsel for has granted appearance for opposite party number 2 on advance notice. Advance notice. And both the counsel appearing for the parties have conjointly submitted that the parties have settled the dispute, and seeking an adjournment for producing the joint affidavit and their claims before the court, least in atonement. Yes.
May I please, your lordship, my lord. Arising out of a 138 NI Act, my lord, I have challenged the order of cognizance, my lord.
Yes.
On 3 grounds, my lord. Firstly, my lord, 223 1 BNSS is not compliant. I have not been given an opportunity after the case is registered. 223 1 says that on a complaint case, the accused must be given an opportunity to be heard. That I have quoted, my lord. And thereapter, my lord,
these are special statute. The 130.
yes, I'm
the
coming.
NI Act is the code on itself.
Apart from this, my lord,
Yes.
I'm having other
That's the
grounds.
weakest point you have. Come to the strongest point.
Yes, my lord.
Yes.
And while the check is presented,
Yes.
it has been returned as account blocked. Account has not been blocked under my instruction. It has been blocked by the banker. And it is there. And thereafter, my lord,
Because of your conduct only.
no, my lord. No, my lord, I may not be so. I'm not operating with that bank. I'm operating with other banks. And thereafter, my lord, the check amount and the demanded amount, which is depicted in the complaint case, is different. He has a demand of on the complaint case, my lord.
Let us see.
My lord, page.
You simply tell me whether you have issued
Page
check or
6,
not.
my lord. Page 6, my lord. He has claimed a demand of 11,70,000, which he wants to get from me. But the check is presented for 14,20,000. That is a differential amount. And that apart, my lord, the notice, pleader notice sent to me is not served on me. It has been returned.
How many checks?
My lord, he is saying about 3 checks, but in this check, in this complaint case, there is 1 check. There is 1 check. My lord, kindly have a glance to page 9.
Para 7. Just read para 7.
Yes,
Read
my lord,
para-
I had gone through.
Read it.
Yes, my lord, I'm placing that the complainant paid to the accused person by UPI transaction amount of rupees
11,70,000. And cash of 3 lakh.
Cash 3
So
lakh.
you added
Agreed.
14,70,000. And you got the check.
Why the check is of 14,20,000? The check is presented for 14,20,000. And that apart, my lord, I'm coming, my lord. And that apart, the demand notice has not been served on the complainant.
That also there will be answer. I'll just.
Yes, my lord. That is not served. While I search for the entire certified copy of the order sheet, from it has not been reflected. Thereafter, it is on the complaint case.
Para 12. Read para 12.
25 page.
No,
Para 12.
serve in.
Para 12.
Yes, my lord.
Read
Correct
it.
address is 25
Para 12.
No, sir, it has not been served on me.
Read it.
Yes, my lord, I am placing. That though my advocate issued pleader notice on dated 22/6/2024 through the registered post in the name of accused person in his correct address, provided
So
my
now the onus is he's had to prove that he has served notice. But there is a pleading in a complaint.
Yes.
He has issued notice.
Yes,
That
but-
onus is on him. Now he will prove it. If he can't prove, then you are out. It has to be tested in the trial only.
But,
That's the law.
can I say one
Yes,
thing more?
yes.
Sir, that returned, which check is, which notice is returned, that has been annexed with the complaint case. That has
Those
been
things
annexed.
you have to confront you when he will come to the witness box. You have to confront him.
Well, it will unnecessarily legal.
Unnecessary, but that's
Can
the
I-
law. What to do? There is a procedure for that. In 482, I can't decide everything like this.
I do agree, my lord. I
don't think.
I do agree, my lord. Let a notice be served.
No. And why these court is clubbed with this kind of cases. for no reason.
No,
If there is no prima facie, there is no case, no case.
But
Why do you waste your time?
But in this case, my lord, if your lordship will come to this.
I issue notice if you deposit 20%.
No, my lord, I'm unable. I'm a poor man. I'm a
Maybe 143 compliance if you do, I'll issue notice. If 143 compliance you will not do, I'll not issue notice. Simple. Simple.
My lord,
Nothing less, nothing.
No notice is served. No notice is served.
He has pleaded, sir. He has to prove
He
it.
has pleaded as because he has sent the notices on the name of
You don't understand what I'm saying.
Yes, my lord.
In a complaint case,
Yes.
in 138, he has to issue notice. That is mandatory requirement.
Yes.
He has said that I have complied with the mandatory requirement. 1 minute. Complied with the mandatory requirement. According to you, he has not done it.
Yes.
Then the onus is on his head. First, when he will come to the witness box, you have to confront him. If you can bring in the evidence that the notice was not served on you, this for the non-compliance of the statutory requirement, 138 proceeding will be dropped. But once he pleads that I have done, I can't doubt it today.
Yes, he has served notice on the wife of the petitioner, my lord. He has.
Again, you are saying.
It is
all this thing you put. See, wife also issued a check.
No, he has
Yes,
not issued a check.
See,
No,
family members, he says.
No, my lord. My wife has never issued a check.
Anyway, I can't go into all this thing.
Your lordship.
I can't go into all this.
Your lordship kindly issue notice so that the differential.
143, complying 143.
Poor man, my lord.
One complaint is entertained, 143, you have to comply.
Salesman, my lord.
No.
Salesman, from where, what source he will collect this?
If you want notice, then if in the trial court also you have to deposit.
No, but
143 is a mandatory ground.
Let me take an instruction.
No. I will not
take an instruction.
We are neither you are bound by.
No, my lord, if
we are at the mercy of your client.
No, my lord.
As the law, whatever
I'm praying, my lord.
Why are you wasting time unnecessarily?
No, my lord.
Subject to compliance of 143 issue notice to the opposite party. Subject to petition compliance.
He cannot arrange
the requirement of 143 NIS. Yes. You reply and 143 comply. I'll see. Once he comes, then we'll see.
I'll take an instruction to that effect, my lord. Let it be come on Monday.
You will seek instruction whether legal provisions has to be complied by your side.
He can arrange this much of money. It's a big amount. For a salesman,
if it is a requirement under law,
yes,
we don't need your client's instruction.
Wholesaler.
Whether you will ask whether this
wholesaler, no, he's salesman.
Whatever. Subject to compliance of 143 issue notice. Yes, next. 19.
Can I pray one interim order in that?
138, there can't be stay. The statutory bar, 6 months. Better I'll give a short date, first week of January. You deposit that requisite and we will persuade him and settle the dispute. That's a better idea. The moment you give it, I'll send it to mediation and finish it up.
Yes.
Okay.
Yes.
Yes.
Please, your lordship. My lord. My lord. My lord,
Yes,
my lord, the petitioner is a home guard, my lord. My lord, kindly have a home guard, my lord.
Home guard.
My lord. My lord, kindly have a glance, my lord. In the day of occurrence, my lord, petitioner is in election duty, my lord.
Yes.
My lord, kindly have a glance in page number 12, my lord, annex 2, my lord.
2, okay. Yes.
My lord, the petitioner name is P. Naik, my lord. My lord, in pura uppara 161, my lord. P. Naik.
P. Naik, yes.
My lord, pura last, my lord.
P. There are how many P. Naiks?
Two, my lord, one P. Pradhana and second is P. Naik, N-A-I-K, and
third is also P. Naik.
Naik, my lord.
Yes.
My lord, this is he is the home guard, my lord.
How do you know which P. Naik you are?
My lord, 161 number is there, my lord.
So that has to be tested.
My lord.
That's the only thing which tests.
My lord, 161, my lord.
How many P. Naiks are there? Whether this P. Naik.
No, my lord, spelling is here, my lord. N-A-Y-A-K, my lord.
There are many P. Naiks.
My lord, what happened, my lord?
And you yourself have said that 2 P. Naiks are there.
My lord. My lord, what happened?
Yes.
My lord, this home guard is working in Barcode police station, my lord.
Yes.
Because of he's a local person, my lord. Say area re court police, my lord, ke ganjai.
What is the stage?
My lord, charge sheet है नहीं.
Investigation is going.
Investigation going on, my lord.
Yeah, then you give this to the IO. Let us see. Let the IO.
Produced and before the inbusiness and relied that document that on very fateful day of the occurrence I am in election duty.
I know it's a plea of alibi.
मतलब सब मतलब actually से जेहेतु होमगार्ड my lord no work no pay my lord मतलब से बिचारा काले को जो लुचिक रहुची सेटा असुविधा.
That's right, but plea of alibi is a
my lord
in effect.
My lord, everything is
to be established in the trial only.
No my lord.
And now investigation is going on.
My lord what happened my lord bail से नहीं तो तेणु से लोकटी लुचिक रहुची my lord बड़ा हैरान होची. That is the problem my lord. और किछ नहीं. My lord kindly have answered in the
see the offenses. What are the offenses?
My lord आनार भी किसी offense विशेष नहीं. My lord से माने
323 and all you will get all are.
My lord kind of class my lord. My lord on dated my lord 23rd 5 2024 my lord. My lord दिन 4टा समय से माने आसी मारिले से my lord last time आघात लगी मुंडरे रक्तस्राव हैला मु घर को पहुंचवा परे मोर स्त्री अवस्था नहीं बारकोट डाक्तरखाना को आनी चिकित्सा करी चिकित्सा सारी स्त्री को घर को नहीं गली समय माय लॉर्ड देन आमर रोल आसला माय लॉर्ड समय प्राय राति 11टा हेबो से माने फोन करी तार सहयोगी माय लॉर्ड पतिनायक एंड लोकनाथ साहू एमाने माय लॉर्ड तापरे गोटे लोक को बाड़े की ता मुंडा फटै छन माय लॉर्ड से मेडिकल माय लॉर्ड आसी घरे अछि इन द टाइम ऑफ माय लॉर्ड इन 10 PM माय लॉर्ड 11टा भितर से माने थाना आसिकी आको बाड़ेले माय लॉर्ड जेहेतु ये पूर्व जो गंजेई बिजनेस कर ये बारंबार खबरटी दे दिए.
Let them inquire. Let them.
My lord.
Seeking quashing of the FIR number so for alleged commission of offence so. Learned counsel for the petition submits that the petitioner is employed in the home guard and in the date of incident he was working where?
One barcode police my lord. Barcode police station in a home guard. Say same police station my lord.
He was on her duty, so there is no probability of her being present at the spot of occurrence. The investigation in the criminal case is still going on. Therefore, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to submit the documents which has been annexed with the petition. And apprise this aspect to the IO of the case. It is expected that the IO shall take into consideration all these aspects in accordance with the law and the same while finding a report of the final form under section 173 CRPC. With this observation, the petition is disposed of. Yes, next.
Oblige, my lord.
20. May I please? In this case, sir, petition challenging the order dated manner 16/11/2024 passed by the executive magistrate cum sub-collector of Khurda under section
yes
163 BNS corresponding 144 CRPC my lord. While the matter subject before the competent court in the civil court my lord, before the Law and Civil Judge Senior Division Banpur my lord. As per answer 1, we challenge the answer 1. My lord, telling the answer 1, my lord. Or
what happened in that order?
My lord, restraining the present petition to harvest the paddy crop raised by the present petition.
My learned friend is saying that there is a civil suit is pending before the parties. Whether in 39(1) and 2 there is an interim order status order is there, not having filed. Lordship, how the 144 the like?
Don't expect much from these petitions. There will be nothing.
Lordship,
everything orally they'll tell, but nothing is written.
Copy
no pleading, no document, nothing.
The supplemental likely restrained the lordship.
Can I see the page 12 of the order of?
Why have you placed these things before the magistrate?
Yes, my lord. Before the
you have not placed here.
Raised before the magistrate already. And also before the civil court.
Show me that you have informed.
Page 8 could reflect Koruni. This is my
no, objection deju. So cause deju.
Where is that objection?
Objection already filed subsequently, my lord.
Where am I not entitled to at least see the objection?
Yes, my lord.
To decide whether the order is wrong or right.
Already, my lord, the crop raised, my lord, the inquiry report, can you see the inquiry report, my lord? So, there is the crop raised by the president, inquiry report.
Have you raised all these points before the court below or not?
Yes,
Before
but
magistrate. How will I know these things?
we raised the before the law and court bill, my lord, pays civil court, my lord, can you see the order of the civil court?
Simple issue notice.
My lord?
Yes. I just issue notice.
Hello.
This petition is bereft of anything.
Well, can you see the order of the honorable court?
On the basis of order, I will not decide it.
Page 12, my lord.
There is no pleading, there is nothing, no document.
There, my lord, can you see the?
I'll just issue notice to help you out. That's all.
Hello.
For second week.
The
Yes.
civil court pending is
What can I do? How will I know? Neither the claim you have filed,
yes, my lord, I raised the my
you keep it with you.
my we already raised my order of the before the law and court.
I
Can you see the order of the law and court below civil court, my lord? Can you see?
20.
My lord, page.
I have issued notice. Let us see.
Damage is you again. Already raised by the
Who will be responsible? You will be responsible because the kind of petition you filed.
Already, can you see the order of the civil court?
No, I have seen it. Everything. I have seen.
Already raised before the already
I have
filed
seen
the
it.
objection. Can you see the civil court order?
In any case, I will have to.
Unless 3 can see.
In any case, I will have to see the other side. I have to ask the other side also. How will I decide whose crop is this? Unless he comes and says.
File the inquiry report, my lord. Already inquiry report.
No. Let her come first week. I'm listing it in the first week. In this kind of petition also, I'm issuing notice. What to do? Yes.
May I please your lordship?
My lord, short date, my lord.
Short date only.
My lord, before we get first week.
First week only.
Damage is again. Say dano nosto is again.
Sir, first week I have already given.
Can I say damage is you?
You have damaged so much now. You have damaged so much. Wait. First week will take you. But when you file the petition, at least file the documents. Make some pleading.
My lord, already the inquiry report, file the inquiry report, the top rate.
You can't select the document. The court is entitled to know what was the case before trial court, what was the objection. And you need an entry model and everything without filing. No, I have seen it. I have seen it. You can't select the document file. Let us not waste the time. Yes.
May I please your lordship, madam? The petitioner is challenging the cognizance order, my lord, by the annexure 4.
Yes.
The cognizance order under section 323.
4, huh?
Yes, ma'am.
Yes.
Annexure 4.
Yes.
And the dispute between the parties with the family members and the purely civil nature matter.
323, 325.
Yes, yes.
What?
And that is.
I issue notice. Let them come. Issue notice.
One IA then.
I also issue notice. I also issue notice. It's a cognizance only. You bring them in. Second week, bring them, we will settle it.
Yes.
Yes.
22 ରେ ସେ 450 guarantee ପାଇଁ କହିଛନ୍ତି ସେ condition ଟାକୁ avoid କରିବା ପାଇଁ ସେ ଗୋଟେ petition file କରିଛନ୍ତି ଏଠି approach କରିଛନ୍ତି to avoid the condition number.
My respectful submission, my lord, I am a vehicle owner. I am not accused in NDPS case. This is a taxi vehicle. My the law and trial court already released my vehicle by order dated. Only change the condition. It is not possible for the petitioner to deposit 50,000. My vehicle was now excise custody 1 year above. More, I am a taxi मालिक मोर 3 लाख टका लोन
डिजायर गाड़ी छु
खाइया को पाउनी बतने वर्षे केते दिन हला मो गाड़ी सीज हेकी पड़छि बैटरी भी डाउन हे गाड़ी बंची केमति बतने मु टेम्पू चलाउथली टेम्पू रो लोन करी करी टैक्सी किनली छे किए गाड़ी भाड़ा
which model
Maruti Suzuki Dzire XVI and VXI sorry VXI
the model which year model
year of model
model my lord
let's see which year
टैक्सी गाड़ी my lord एटा हो मॉडल my lord Maruti Dzire XVIXI car bearing registration number OD 33AE 3439 chassis number 201517 engine number K number 4271
which model you don't know do you have any idea which model
not less than 7 lakhs onwards lordship second is number show करछि recently OD number 33
Yeah,
AE,
2 years
Bhubaneswar station number OD.
ଗାଡି ଯେ 2 years back ମୁଁ ଲୋନ କରି ନୂଆ ଗାଡିଟା କିଣିଛି ସେମାନେ ଭଡାରେ ଯାଇକିରି କାମ କଲେ ଆଇ ଏମ୍ ନଟ୍ ଆକ୍ୟୁଜ ଆଇ ଏମ୍ ନଟ୍ ମୁଁ ଟେମ୍ପୁ ଚଲାଉଥିଲି ଟେମ୍ପୁ ଚଲେଇବାରୁ ଗାଡି ଖଣ୍ଡେ ଲୋନ କରି କିଣିଲି ବର୍ତ୍ତମାନ ବର୍ଷେ କେତେ ମାସ ହେଲା ମୋର ଗାଡି ଥୁଆ ହେଇଛି ମୁଁ ଡୋର ଟୁ ଡୋର ବୁଲିକି
He says he is a taxi driver. What to do?
But
ନାଇଁ ଆମେ ଓନର ଭାଇ
His livelihood is affected.
that we consider.
Livelihood is affected.
our
Taxi driver,
NSS
where from he?
and
50,000 for the
50,000 and one more submission also they are mentioned for waiver.
and indemnity bond of 5 lakhs is giving in any
Yes,
case.
yes, yes.
And for 50,000 is not
20,000,
position.
30,000, 30,000 also.
I'll reduce to 25,000. Okay.
ମାଇଲଡ଼ ଟିକେ ଆଉ କିଛି ନାହିଁ ଆମ ପାଖରେ ଭିକାରୀ ହେଇଗଲୁ ଆମେ ଟ୍ୟାକ୍ସି ଡ୍ରାଇଭର
Yes.
ବସେଇ ଗାଡି ବନ୍ଦ
He has engaged you. You can't say that he doesn't have the money.
ମୁଁ ଯଦି 50,000 ଦେଇଥାନ୍ତି ଗାଡି ଯଦି 50,000 ଟଙ୍କା ଦେଇ ଦେଇଥାନ୍ତି 4 ମାସ ତଳରୁ ଗାଡି ଯାଆନ୍ତାନି all condition I complied except
Let poor guy, let him. I'll increase the indemnity bond to 550. That's a better idea. Petitioner is agreed by the petitioner's application under section 457 CRPC has been for release of the Maruti Suzuki Desire.
Yes, sir.
VXI bearing number bearing number OD 33A3439 has been directed to be released. However, with a condition that he shall furnish indemnity bond of rupees 5 lakhs and also furnish a bank guarantee of 50,000 rupees. 50,000 rupees. The petitioner is agreed by the condition imposed by the court below while releasing his vehicle. And on counsel for the petitioner submits that the petitioner is a taxi driver and he is unable to arrange 50,000 rupees to furnish bank guarantee. Therefore, the vehicle is when was it seized?
14/5/2023
Vehicle is 2023. You are an accused?
accused by lord I am not accused by lord accused person of illusion bail
accused petitioner is not even accused in the NDPS case where the vehicle has been entered. You are the owner, huh?
Paragraph 8 mention is owner of the vehicle. Listed owner of the vehicle was present.
Submits that the leniency should be lenient approach should be adopted. Looking into the financial stress the petitioner is facing. I am inclined to modify the order to the extent that the petitioner shall furnish execute an indemnity bond of rupees 5 lakhs, 6 lakhs, 6 lakhs, and on the basis of the same indemnity bond, the vehicle may be released, dispensing furnishing of bandit. Yes. Yes, allowed.
May I please, your lordship? The petitioner is challenging Annexure 3. Thereby, my lord, Annexure 3 the rejection order of the 205 petition. That it was rejected. Kindly have a glance at the page number 15, my lord.
What are the offenses?
Offenses, my lord, 214, 506, 418. This is the on the basis of the complaint they have filed, my lord, I'm saying. The cognizance report is not, my lord. No, it's initially FIR was lost, but on the ground that it is a mistake of fact, the police filed the final form and thereafter a protest petition was filed in this step.
Yes.
The fact of the case is like this. The complainant is
show me the medical document of Usarani Sahu.
My lord, annexed at page 17, my lord. 17 to 21.
17?
Page 17 to 21.
Yes.
There are many documents, my lord.
It's a complaint case.
It's a complaint
issue
case.
notice. I'll issue notice. Yes.
24.
May I please, Your Lordship, madam? Before I start my case, my lord, I would like to quote my lord's quotation in a case, my lord. That is reported, my lord, in 2496 OCR. The pain of loneliness, despair, and agony suffered by a mind contemplating suicide have been realistically captured by the American President Abraham Lincoln in following lines, my lord. The same thing happened here. Yes, my lord. Either I am the victim, my lord. Because after 15 days of marriage, I went to my job, my lord. And thereafter, after 6 months, my wife committed suicide, my lord. Ask is what to do. And what about the other offences, like 493, 304B, 306, charge sheet may submitted, my lord. At page 45. Yes. 55. I'll just issue notice, let us see. Yes, yes. And also they are ready to compromise. Let us see. Matrimonial dispute. Yes. I also. You move application for adjournment. Yes. Oblige.
25.
Lordship, in item 25, I'm praying for an adjournment or lordship after that.
Adjournment?
Yes, sir, lordship.
Request for this. I'll just write. I'll just go back. Yes, 1 minute. Yes, but 26.
26.
May I please, Your Lordship? Well, the petitioner has challenged the arrest of 3 Miller, rejecting my petition under section 311 CRPC to recall PW 5.
Sir?
To recall PW 5, the victim Miller.
PW 5?
Miller.
No, you moved application for PW 21, 22, 23.
That was allowed, Miller.
Allowed.
No, that was allowed.
PW
5 Miller.
Victim. What are the offences?
Offences is Miller to 376 2N 506 and 6 of the POCSO Act.
Oh, there is a bar.
There is a bar repeated 30, but this is for the first time, Miller.
But whatever, there is a legal bar. It may not be absolute bar, but there is a legal bar. 35.5. 35.5
Miller, but repeatedly. That is what have been stated repeatedly. But it's not repeated, not first time, Miller. I have prepared the
But where are the questions?
Questions, Miller, Annex 2, Miller.
Huh?
Annex 2, Miller.
To me, Annex 2.
At page...
Page 14. It starts from
page 14, Miller. But the first time, Miller, I have recalled, Miller, not repeatedly second time or third time.
Well, see the questions. What are the relevant questions?
The relevance is, Miller, regarding 164.
What are you asking? This question you will ask to the victim girl who is a minor. Just see the question. You satisfy yourself.
But he says that she says that
I don't think you can't put these questions to the minor. See, the idea of 35.3 is you can't subject a victim to this kind of grilling. It is a humiliation to her. That she is a minor. See, the kind of questions you have framed, I don't think these questions could be permitted. And you, in 3 questions you have asked leading questions.
That
you write what are the time gap between the first sexual intercourse and the disclosure of the incident to the victim, their aunt. How can you ask this question?
No, F, question number F, here, Lordship, can see.
And that, what is the time gap between the last sexual intercourse?
How many months
after? Can you ask all those questions to the victim? I am not impressed by any single question.
F, here, Lordship, can see. F. Yes, ma'am. How many months, days after the first sexual intercourse, she conceived and in which month in the year?
You are going to ask the victim. You are asking the question to, you can ask this question to the mother. She did. How many months or days after the first sexual intercourse she conceived? She conceived means the victim conceived.
Yes.
And in which month and year? This you can ask to the mother, not to the victim. You can't ask these questions. Madam, petitioner
Learned court has observed.
order dated 13/2/2023, whereby his application for recalling of the witnesses, namely PW 21, 22, 23, and PW 5 has been partly allowed. Although the although the trial court has allowed to recall PW 21, 22, and 23, however, rejected the prayer vis-a-vis PW 5, who is the victim in the present case. The petitioner is agreed by that. The trial court has rejected the application for the petitioner for recalling PW 5, apparently because of the bar contained under section 33, clause 5 of POCSO Act. Apart from that, I have perused the application under section 311 CRPC. In the application, in para 1, the following questions have been framed by the petitioner. Following proposed questions were framed by the petitioner to be put to the victim minor girl. I have perused all the questions carefully, and for the opinion that these questions are not relevant and cannot be put to the victim girl. On that ground, apart from the fact that there is a legal bar to repeatedly call the witness, minor witness, to the witness box, I am convinced that the questions proposed to be put to the witnesses are not relevant. Hence, the trial, no interference is called for according to the petition in dismiss. That gone for the petition seeks leave of the court to plead complaint in the opposite party, informant of the opposite party number 2. Yes. 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 Which one? Yes.
73.
73. POCSO. What to do?
My lords, my lords, both parties are present.
Both party may be present, but there is a judgment against you. Have you read that judgment?
No, my lords.
You read that judgment. How will you get over that judgment? You have to read that judgment. Simply urgent. You read that judgment and come. District. Yes.
My lords, affidavit.
Affidavit, I'll take it later on.
My
If
lords.
you get over that judgment, then only the question of affidavit comes.
My lords.
You read that judgment. How will you distinguish your case from that judgment of Supreme Court? You just tell me. Then
My
only I can entertain this petition. Otherwise, I can't.
My lords.
Because there is a judgment written by me.
My
According
lords.
to that judgment, you are covered.
My lords.
But subsequently, there is recent judgment of Supreme Court, and that judgment is creating problem for you. You just check it up, that judgment, and tell me how to distinguish that judgment in the facts of your case. Yes. Next.
27.
May I please, my lord? My lord, in this case, the petitioners are challenging the rejection of recall of PW1 and PW13, my lord. My lord, in this case, kindly have a glance in page number 9, my lord. The petitioners and the accused persons have already been compromised the matter, and accordingly, they have filed on compounding of offences, my lord. And as per their petition, all the offences which are compoundable has already been compounded, my lord. Only the non-compoundable offences like 307, 354, 452 are in trial, my lord. For which they have prayed for a recall of PW1 and PW13. My lord, PW1 is the informant and PW13 is the injured, my lord.
Yes. Yes,
Only
Mr.
to
Mishra.
Here the 311.
See, they have been charged with many provisions.
Well,
They have compounded the offences in so far the compoundable offences are concerned. Non-compoundable offences, they want to bring these witnesses, recall these witnesses so that it will be over.
Yes.
They might have deposed against them.
Yes.
Allow it. I don't know. Petitioner is agreed by the order dated 18/11/2024 passed by Learned Assistant Sessions come Women's Judge both, whereby his application, whereby his or her application, whereby their application under section 311 CRPC for recalling which witnesses? Two.
PW1 and PW13, my lord. PW1 and 1 and 13, my lord.
PW1 and 13 has been turned down. Mr. Mishra, Mr. Preetham Mishra, Learned Counsel for the petitioner submits that the petitioners were charged for alleged offences punishable under section 147/294/5 322, 325, 506, 354, 307, 149 IPC. The parties have settled their dispute. Therefore, they moved an application under section 320 bracket 2 of CRPC. The said application vis-a-vis the offences which are compoundable has been allowed. However, the offences which are not compoundable, the petitioner are facing trial. At that stage, they moved an application under section 311 CRPC for recalling the PW1, who is the informant in the case, and PW13 is injured in the case, which has been turned down by the impugn order. For the reasons stated in the application, present application, the present application and the fact that the petitioners have settled the dispute with the victim as well as the informant, the petition deserves merit. Accordingly, the application moved by the petitioner under section 311 CRPC deserves merit, and accordingly allowed. The trial court is directed to recall these witnesses, recall PW1 and 13 by fixing a particular date, and the petitioners will be afforded. Will be afforded a singular opportunity to further examine, further cross-examine the witnesses without taking unnecessary exams. The petitioner may furnish the proposed questions beforehand, and the trial court, it is open for the trial court to examine the relevancy of those questions to be put to the same. This observation petition is allowed. Yes.
28.
May I please, your lordship? My lord, in this case, this case was arising out of NA Act. 205 petition was allowed. Thereafter, due to wrong entry in the diary, the Lanka council could not take steps.
I'll allow the petition. Petition is agreed by the order dated 5/4/2024, whereby NBW has been issued against him. The petitioner is an accused in what is this one CC case number 79 of 2015, initiated by the opposite party for alleged offence under section 138 NIA. तब लिख दो 31st तक नहीं आज कर दियो तुम 10th of January 10th of January yes ठीक है hello आज शुरू 10th January yes
29 Miller, Belgium matter, your lordship.
Yes, tell me.
NBW order dated 16/5/2024 at running case 9, your lordship.
Bail
Miller. On 18/11/2019, your lordship.
19 okay 500 okay yes
30.
आज High Court bar court of
May please, your lordship.
yes 30
This is against the order taking cognizance, my lord. Well, in fact, if your lordship will kindly turn to the FIR, there is absolutely no allegation against the present petitioner, excepting the allegation that he is the managing director of the construction company, my lord. There is a construction company. Petitioner is the managing director, my lord. My lord, they are constructing a road, my lord, leading from Gunpur to Putta Singh, my lord. And they have a mines lease in their favor, my lord. And one supervisor was there who was in charge of the my lord, management of the. Some explosives were kept in the premises of that mines area, my lord. And those were seized by the police, and the FIR has been instituted. My lord, saying that this petitioner was the managing director, so my lord, he is also implicated in the case, my lord. My lord, anyway, my lord, what has happened, my lord? This petitioner had applied for anticipatory bail, my lord. The anticipatory bail direction was issued that he will, my lord, appear before the police station. Interim order was passed, my lord, and he shall be released on furnishing bail bond, my lord.
Right.
My lord, thereafter, the case was taken up after 2-3 years, my lord. And the case was disposed of, directing that petitioner shall surrender, my lord. This subsequent order was never brought to the knowledge of the petitioner, my lord. So he could not avail the opportunity there, my lord, by surrendering before the court below, my lord. That order, if your lordship will kindly have a glance, my lord.
You show me the first order and second order.
First order ta to upload ହେଇନି, second order ta mo pakhare ଅଛି.
You want benefit of the first order.
ସେଇଠି ଯାଇକିରି bail ରେ ଯାଆନ୍ତୁ, ସେ he will face the trial, there is no difficulty.
Submission going through the
Along with others, he will face the trial.
for the giving in view the surrounding circumstances is also concerning the petitioner. Absence of any impediment, it is directed after the individual petitioner surrender of the court initiation and also within 3 weeks and so move their release on date. This will be directed
ସେଇଟାକୁ ଖାଲି କହିଦେଲେ ସେ
this was passed.
This order was passed, my lord. It was not never brought to the notice of the petitioner, my lord. So that is why he could not avail the opportunity, my lord.
Notice, but you have filed the petition. Who will give you?
File करथिले जे एठी जे file करथिले advocate, he had never communicated to me, my lord, that subsequently this order has been passed.
There is an order of High Court.
Yes.
He wants to take benefit of that order.
Yes, ma'am.
Let him do it.
That your lordship.
Right. Petitioner although has assailed the order dated 28/7/2020, whereby cognizance of offences punishable under section. Where is that order?
My lord, cognizance order is at annexure, my lord.
20. Cognizance of the offences punishable under section. Under section 20 has been taken against him. However, he submits that he would reserve right to agitate all the points before the court below at appropriate stage. Appropriate. Mr. Mishra, next one. Mr. Mishra, having said that, Mr. Mishra further points out that the present petitioner had applied for anticipatory bail before this court by moving AVAPL number 14342 of 2019. The coding bench of this court by the order dated 15/9/2021 has disposed of the application inter alia stating as on the para 3. Para 3. He submits that he would avail the benefit of the said order by surrendering. Regarding head to the mentioned, the petitioner is granted liberty to appear or surrender before the court below on or before the 10th of January 2025 and move appropriate application in the light of the observation made by the coordinate bench in ABPA number so and so, in the order dated so and so in ABPA so and so. Hello.
31.
30?
Yes. 31, may I bless you?
Yes.
Application, my lordship, that the present petitioner filed for 482 application.
Also is there.
POCSO is there, my lordship. The fact of the case, my lord, initially in annexure 1, the FIR has been lodged against the present petition under section 363. Later, it was turned into the 63, 376, 2N and 10934 IPC and read with section 6 of POCSO Act. Only, my lordship, is a case arising out of consensual relationship between them.
He seeks indulgence of this court for quashing of the proceeding. Issue notice opposite party number 2, case of Pratap accept notice for the state. Lease the matter in the first week. Yes. First week or second week. Yes.
34.
Yes,
In
sir.
this decisional court, my lord, the wife and minor daughter who are victims of a Domestic Violence Act as before the decisional court, as inaction going on, the complaint file before London SDGM Puri in year 2013 is going on. And although the warrant was issued, that is not executed, is helpless to get some sustenance. That is the reason I have approached the decisional court, sir.
Where is the warrant?
My lord?
Where is that warrant issued? You see,
Yes, sir. Lordship gets it.
You are
at
seeking a direction.
Yes, sir. Lordship gets it at page 14.
14.
Yes, sir.
Yes.
Page 14. Order number. Lordship get it 1923. Order number 1923.
14, huh?
Yes, sir. Page 14, my lord. Running page.
Sure. Yes. BW issued. BW issued.
Advocate for the complainant files Hajira. Advocate for the
NBW issue.
files. Nothing is being done as on date.
And you are seeking direction to whom? Direction to the superintendent of police. Urda. That petitioner is seeking in the present petition is seeking following direction. Then counsel for the petitioner submits that the petitioner number 1 is the wife of opposite party, and the petitioner number 2 is their daughter. Their daughter. Although what is this proceeding you have initiated? DVA.
Domestic, yes, sir. Domestic Violence Act.
Also, although she has filed initiated the proceeding under section 15(4) of what are the execution proceeding?
Yes, my lord. That the interim maintenance was granted 4,000 rupees.
Although interim maintenance order has been issued by the court below, but the opposite party has been avoiding to make good the maintenance amount to the petitioners. An execution proceeding has been initiated by the petitioners, being execution miss case number 7 of 2023. In the said proceeding, the court below has issued NBW against the petitioner by order dated 1/9/2023. However, the said NBW has not yet been executed. Hence, he is agreed and seeks direction to the Superintendent of Police, Khurda, to get the NBW executed so that the petitioners can get maintenance, so that the execution petition could proceed and the petitioner can get the maintenance amount. The prayer made by the petitioner in the present proceeding is innocent, hence deserves merit. Hence deserves merit. Accordingly, the superintendent of police is directed to take necessary steps to ensure that the NBW issued by the court below is executed. With this observation, the petition is disposed. Yes. Next.
35.
Right, please, Your Lordship.
Yes.
Not rightly or wrongly, the investigating officer arrested the present petitioner, and since February 2024, my lord, the present petitioner is languishing in judicial custody. After the charge sheet submitted, my lord, under section 363, 366, 376, 2N, 376, 3, 313, 294, 32, 323, 34 of the IPC. So also, my lord, section 4, subsection 2 and 6 of the POCSO Act. My lord, following the prosecution case, fake investigation, my lord,
What are you seeking?
My lord, I am coming.
Yeah.
The petitioner filed a petition, my lord, under 34 to subsection 2 of the POCSO Act, wherein, my lord, the petitioner praying for the ascertain the victim.
And he has signed, and your lordship see that 606, who signed it, my lord? Amar signs it.
Other parties are in same agreement.
And Jitendra signs it.
I have heard yesterday, so extensively. Thereafter, I was venturing into the documents also. I find
For me, there is absolutely nothing. What have I done?
Who are the other parties? Kindly see. Page 109.
The best case against my lord, he thinks I should have been with him litigating, my lord.
Certainly, you will have to pay, therefore you litigate.
Okay, I'll just
Right.
pass it.
So,
My lord, he cannot go hot and cold at the same time.
I understand.
Yes, my lord.
His matter.
But I suggest you pull yourself, collect the money and pay something. Finish it up.
My lord, they are huge companies if they want to pay more. But there is nothing against me, my lord.
I'm not saying you, the other people.
Yes, my lord. The other people, my lord.
I'll tell you the amount of money you would be spending in the litigating. He pull that money and give him.
that will cover up.
I know at the end of the day,
He's also spending
everything.
He's also
End of the day, defend yourself. You will spend more than
He's spending huge amounts, my lord. I don't know if he's spending it. But anyway, my lord. Anyway, that is not the issue. My lord, my case
It is
stands
for the
on.
benefit of the bar.
Your lordships may bear in mind that my case stands on a different footing. I argue.
I'll definitely deal with it.
Yes, my lord. So your lordships
Nine
will
I'll
deal
deal
with it in a different capacity.
Separate, not with the page matters.
Yes. I'll separately deal.
Oh,
Yes, Your Lordship. Grateful man.
I passed an common interim order so that the investigation should proceed. Till 9th,
so
till 9th, let us see.
After that,
All are documentary evidence.
Exactly, my lord.
Also.
Let them have a copy.
Yes.
Hey,
And
heavy copy.
see the volume which you have filed here,
Yes, sir.
and the hard copy you give it to Mr. Jena
Yes.
by evening.
Yes.
Hard copy.
My lord's a heavy copy, my lord.
So you have to give it.
Heavy people will have heavy copies only.
No, my lord.
We are small people, my lords. He says I am a Lordia entrepreneur, my lords. I am also a Lordia entrepreneur.
The number of documents which you filed
Yes.
itself deserves one thing, that it should be dismissed so that the police will look into it.
Well, let him also serve a copy on this.
Yes,
Please.
certainly.
Hard copy you give it.
Yes,
There is a reason behind it. I am saying
Fine.
you give it.
The element is also not functioning. Then it counts as.
Take out the printout, the hard copy with all document. You give it to Mr. Jena.
Yes, my lords, I have a simple prayer, my lords. While considering all the cases, my lords, your lordships have gone through all the documents.
I'll deal separately. Your case.
My case may be dealt with separately.
Separate.
Your lordships may consider a
Shall
separate.
I put it beyond the 9th then?
No.
Separately?
It's okay with 9th. It's okay, but the interim relief that your lordships will consider that I stand on a different footing. My lords.
Yes.
Even the lines attached to me, collusion and other things doesn't
Yes,
make out anything.
I'll look. at it.
Oblige.
Yes.
Oblige.
Next.
37.
After.
Yes.
Olga matter. My lord, ninth is fixed for that matters. Also.
Then the beyond ninth rakh lo.
Beyond ninth, your lordship.
Yes. Yes.
After 90.
That's what they are requesting.
Ninth is-
Ninth.
Ninth is-
Let it be ninth. Yes. Why piecemeal hearing? Yes, next.
37.
37, sir.
37 is a CPI case. They have not served the copy, nor to us, nor it has been reflected in the cause list as state of Orissa.
What is this case?
Yes,
My lord, it's a CBI case, my lord. What happened?
Appeal against conviction.
Yes, your lordship.
Sentence?
4 years, your lordship. Concurrently, the sentence running for 4 years. My lord, interestingly, the petitioner.
Don't argue the matter. Only it is appeal first time it has come.
It's come.
I'll admit it is simple as that. Why?
CBI counsel may be implemented according to.
All right.
My lord, it is filed through online, your lordship. And now the process, my lord, copy darkar purne hai.
Cost title?
Cost title
Cost
ke
title
book-
state of Orissa.
No, no,
You
state
don't
of-
need admission of the appeal?
Yes, your lordship.
Why are you unnecessary arguing?
Beg pardon. Sorry, man.
Cost title should
It's
be.
a appeal. First time the appeal came, I am admitting the usual order I'll pass. Supply a copy
To CPI.
to CBI.
And a cost title to be.
Mr. Cost title Republic.
I will beg pardon, my lord, the
State,
cost title
change.
mentioned.
Change
here.
the cost.
Corrected accordingly.
And supply the copy, lease it tomorrow.
Sarthak Naik.
Lease it tomorrow.
Great, great.
Lease it tomorrow. Correct the cost title, supply the copy to
Mr. Sarthak Naik.
CBI and lease it tomorrow. Yes.
Great.
A formal order I'll pass tomorrow.
Well.
Correct it. Yes. 13. Okay. Good, good.
39.
38.
13. Yes.
It's a Belgium matter, my lord.
Yes, yes. Tell me.
Petitioner was released on bail on 7/4/2018, my lord. And NBW was issued on 24/8/2020.
500. Yes. Next.
40.
My lords, Belgium matter, my lords. Petitioner jumped bail and NBW was issued on 19/3/2024, page 9, your lordship.
Bail.
He was on bail.
Date you don't know.
Bail, my lords. That is
Date
13/2/2012, he was on bail.
500. Yes.
41.
January. Yes.
41, my lord.
41.
Petitioner
Yes.
bail on 3/2/2022, my lord.
Hmm.
And NBW was issued on 16/8/2024, my lord.
24.
Yes, my lord.
Okay.
16/8.
How many of you are there?
5%, my lord.
5. 500 each. Yes.
42.
May I please, lordship? NBW issued on 9/2/2022, my lord. Is released on bail on 13/1/2022.
1000. Yes.
43.
May I please, your lordship? The petitioner was on bail on 7/4/2022. NBW was issued on 6/5/2024.
24. Okay. 500. 500. Yes.
44.
NBW was issued on 10/11/2023.
Yes, my lord.
10/11.
2023.
2023.
Bail. No.
23 and bail? No.
My lordship,
Don't know.
it was not it.
I have attached entire order statement.
Nahi.
Unnecessary one.
Tell me the date. Why are you wasting time?
Date well long code below here religion by. Exactly.
Do you know the date or not?
No.
Or simply say you are on bail. 23 na? 500. Yes. Yes. 45.
45 issued, NBW was issued on 4/8/2023, lords.
Bail.
They were on bail in different dates. There are two petition lordships. One is of 1980-2017 and two is 4/8/2017.
4/8.
Then confusion habo ye earlier on bail lordship for dindu khali.
500.
Plus they were earlier on bail. Simply reflect earlier on bail.
Yes.
46.
May I please, your lordship? In the case of under section 138 of NI Act,
NBW
15/3/2017, 205 of CRPC petition was allowed. And NBW issued on 8/8/2024.
A complaint under section 138 NIA. The petitioner accused moved application under 205 CRPC, which was turned down, and NBW was issued by order dated 8/8/2024. Okay, question.
47.
May I please? NBW issued on 9/2/2024, my lord.
Yes.
Here release on bail 29/1/2020, my lord.
500. Yes.
Problem.
48, my lord. This is, my lord, NBW has been issued, but this is not Belgium, my lord. Here what happened, the petitioner is, my lord, owner of a motorcycle. His motorcycle was stolen in the month of March 2016. Thereafter, in the month of May 2016, the motorcycle was seized in connection with a NDPS case where, my lord, 7 kg of ganja was, my lord, carried. Thereafter, FIR has been lodged against unknown person, and thereafter, charge sheet final PR has been submitted against unknown person that no clue about the accused persons. Thereafter, by the Annexer 3, I have filed, I being the owner, filed a petition under section 457 CRPC for release of my vehicle, and that has been allowed, and the vehicle was returned to me. Thereafter, after 8 years, my lord, in the year 2023, the learned special court issued NBW. Even if, my lord, there is no accused, no cognizance has been taken, NBW that though there is no accused person in this case, so this owner is liable for the same, and NBW was issued. I pray, my lord, let the call for the records and NBW be stayed for till date, my lord. Because
I'll set aside the NBW order and go and
Yes.
tell all the story to trial court. Go and appear and tell all the story.
my lord, I am not accused.
It's all, tell the court, how will I decide?
Cognizance, till date, cognizance has not.
I will not say anything. And the petition is agreed by the order dated to 48/2023, whereby NBW has been issued against him by the special judge come district and session judge in 2A, CC number 2 of 2016. And account for the petition submits that the petitioner has nothing to do with the present case. Rather, the vehicle involved, alleged to have been involved, has been released in his favor, as he was the owner of the vehicle. Subsequently, the trial court has issued the NBW against him. I'm not inclined to dwell upon the merits of the case. However, liberty is granted to the petitioner to raise all the points before the court below. Having said that, the execution of the NBW issued by the trial court by the order dated 2 days after the case, it's date till 10th of January, and the petitioner is granted liberty to appear before the court on or before such and such day and resort to the remedy available under law. Yes.
My lord, Annexer 3 question.
Yes. Next.
49.
49 bail was granted on 5/2/2013 and NBW was issued on 17/7/2017.
17.
Yes.
2000 bar. Yes. High Court bar. Yes.
50.
Lordship, the NBW was issued on 4th May 2023, Lordship. Bail order was granted on 21/5/2018.
18.
Yes.
Bail was 18, huh?
Bail was 18.
Bail was 18 and NBW was issued on 5/20/23.
23. 500 each. Yes.
51.
Even my lord, bail or bail on 3rd May in the year 2000, my lord, and NBW dated 27/9/24.
NBW
27/9/24.
Okay, 500. Yes.
500 my lord, Talcher Bar Association ଅନୁଗୁଳ ହେଇଯାଉଛି ତ।
Talcher bar. Yes.
Obliged.
Talcher bar. Yes.
52.
NBW was issued on 2/9/2022 and the bail was granted on 28/2011.
500. Okay.
appeal on behalf of Mr. Maharana, my lord, let it come after vacation.
He has some problem. 78 weeks for this.
Okay.
Everybody has come in vacation mood, it seems.
Correct, correct.
Yes.
Sorry. Item 9.
Here in this case, kindly have a glance to the bail order granted by this.
Yes.
Kindly see he is the main accused, Karan Kumar Singh, and already charge sheet has been submitted. Page 2, kindly have a glance. Page 2. What are the transactions between this accused and the informant? It is monetary transaction relating to collection, transfer and payment to different agencies, person on online mode through the use of UPI. And kindly have a glance to next page, third page, that period from 7/6/2023 to 19/6/2023.
You are referring to this order?
Yes.
Which part?
Page 3.
Here.
Page 3, middle part, that it is mentioned the informant company that during the period from 7/6/19/6/2023,
yes,
the petitioner has transferred the accused 15 crores from the accounts of the informant, manipulating the dynamic QR code routed through the above accounts of the informant using payout mechanism to 125 unconnected bank accounts. Those had no business relevancy to the informant. So these 125 unconnected bank accounts, which has no business with the informant. And they have also stated that
all the investigation is going on. Let it.
No, not it is completed. Page 5, order of the page 5 kindly have.
Page 5 of
Page 5 of the order.
This is bail application of the main accused.
Yes, charge sheet has submitted.
What is the relevancy of this?
Yes, investigating officer submitted charge sheet on 31/10/2023 under section so and so. And charge sheet has already been submitted against the accused. And here,
when the charge sheet was submitted?
31/10. And himself says that we have already get back 2.83 crore.
Yes.
And they are saying 7/6 to 19/6, and my account shows, but it is not anything come from the accounts of the informant.
Then why have you filed the petition here? Filed 457 there in trial court.
Now I am not a party in this case. I am not a petition accused.
Still you can file.
No, I am not accused.
You can file.
And also,
you can file a separate.
Now also 203 they have not complied. 102 subsection 3. They have not intimated.
All this thing can be gone into by the trial court also. Why have you invoked 482?
Because I am not a party in the trial court.
Right, charge sheet is now filed.
Yes.
You move application. I'll give that liberty.
Keeping open to the investigation.
It is open. 173(8) is open also. You move application. If it doesn't happen, then I'll intervene.
Your lordship may grant me liberty to the CIT court.
That's what I'm saying.
Because more than 1 year have passed.
Petitioner.
More than 1 year passed. They have not connected, and Supreme Court time again says 1023 mandatory you have to follow.
In connection to the FIR
18
EOW Bhubaneswar PS case number 21 of 2023, the account of the present petitioner has been frozen by the investigating officer. The petitioner is not an accused in the FIR. Investigation has already been completed.
Not
And
completed.
31/10.
Investigation has already been completed, and a preliminary charge sheet has been filed on 31 10/2023, keeping further investigation open under section 173.
And main accused has already been released on bail.
Mr. Bahari, learned counsel for the petitioner, relying upon the order dated 14 judgment dated 4/11/2024, passed by the coordinate bench of this court in VLAPL number 14283 of 2023 in regard to the bail plea of the main accused, submits that the main accused has already been admitted to bail. Admitted to bail. The court has deliberated upon the involvement of the principal accused in the said order. Nothing is coming to the fore in regard to the involvement of the present petitioner. Therefore, the account which has been frozen by the investigating officer needs to be relooked, particularly after the preliminary case is filed. I'm not inclined to entertain this petition at this stage because the petitioner has not moved any application before the trial court in that regard. Hence, the petitioner is given liberty to move appropriate application also the trial court in this regard, raising all the contention as has been raised in the present petition, including the ground that the investigating officer has not complied the statutory procedure contemplated under section 102.
And no reason assigned to keep the account frozen for more than 1 year.
To chairman. With this observation, the petition is disposed of with the liberty as per.
Now, may I pray the court name may be mentioned PODC OPID court in city number.
Trial court court below PODC
OPID Cuttack.
Okay.
CP number 7 of 2023.
In CP number 7. Yes. Yes.
14.
Yes, sir.
Lordships, is a compromise matter. Lordship, kindly see the last order, Lord, 25/11/2024.
Yes. Yes. What he says, all the parties have
Lordships, dispense with the last occasion. Lordships, dispense the personal offense.
Where are the accused?
I am the accuser.
Huh?
I am the accuser, Lordships.
No, accused are not present.
Accused
The
inside.
informed victim appeared in person to.
In fact, accused in the custody, Lordships.
Filed at
Lordship, observed that last order.
Investigating it is still on. The treatment of the victim on record. The victim files an affidavit. What is the age of the victim?
Victim is Lordship 27 years.
15 years.
No, Lordship. 27. Aadhaar card is there.
Huh?
Aadhaar is there, Lordships. 27 years. Annexure 2. Annexure 2, Lordships.
Yes.
Yes, Lordships.
It can't be
And
passed.
the meantime, my Lordships, today, Lordship, Honorable High Court has been pleased to pass the bail order against the accused, Lordships, by BLPL number
Here-
11651.
In 164, she has stated everything. What is the age? You show me the age.
Age, Lordship, Annexure 2, your Lordship, kindly see.
27 years.
27 years old.
20?
Date of birth is 97, your Lordship.
27.
Yes, Lordship.
27 of?
24/5/97 date of birth, your Lordship.
Which page?
Page, Lordships, Annexure 2, your Lordship, page 14. your
Aadhaar
Lordship.
card.
Page 14, your Lordship.
97. Hey, what do you say? 97. Date of birth. Aadhaar card.
And now the victim has already got married and present victim already married.
No,
to
no,
another
no.
person.
She will marry. Marriage has been fixed.
Marriage has been fixed.
Petitioner was in custody.
Petitioner is in custody, your Lordship, but
Today he got bail from this court.
Okay. Then I'll keep it on 24th. Let him come. Let him come. Huh? 24th. You have seen the 164 statement. She has said that in the promise of marriage they had relationship, but at the top it is written victim X age, wage, nothing is written. Nothing is written. She doesn't say that what is her age. Aadhaar card is very clear.
She appeared last
occasion.
Where is the question of POXO then?
She
But
appeared
the
last.
time of occurrence, but the present victim is the minor.
No, that is,
In the
he was
occurrence,
occurrence is in.
Bring him on 24th and what?
Yes, Lordship.
Only accused will come, my lord.
Accused
The victim has been.
Victim, I have a victim
Yes.
exempt. Yes.
May I pay relative part order, Lordship? May I pray?
24.
24.
Yes.
31.
How many days he remained in the jail?
Jail, your Lordship, since 23/9/2024, Lordship. 23/9/2024.
Okay, a month or so. Yes.
3 months.
Okay. Yes.
31.
May I please? My humble
Got
prayer.
any judgment?
Judgment is not. Judgment is not with me, Malchi. I am not offended.
31.
Malchi, I only my prayer.
Don't repeat it.
No, only one prayer, Malchi. My Malchi will permit me. One prayer, my Malchi.
Yes, same prayer you will make.
No, Malchi, I will. I'm praying before Malchi. I say, give me liberty to move an application for the on court below.
Where investigation is going on, where will you move application?
The court below, Malchi.
Where? Which court?
The court.
You will go to any court and do it what? Charge sheet is not filed, investigation is going on.
For the land SDGM, Malchi.
In which
The case
proceeding?
is pending there, Malchi.
Investigation is going on.
That has been. I will liberty.
Officer.
Say, I'll say that.
Investigation is going on. Where is the question of court?
I will say liberty to give me surrender before that. I'll move an application before the court. Malchi. Same day disposal, Malchi.
Same day disposal.
Malchi.
Then I'll dispose it up.
Malchi. Disposal with same day disposal.
Where is that? 31, na?
Malchi, 31.
Petitioner is in this present petition is seeking the quashing of the entire criminal prosecution initiated against him. Initiated against him for alleged commission of offences punishable under section 363 CRPC, IPC in Kendrapada Sadar PS case number so and so. The investigation in the present case is still going on. The Learned Counsel for the petitioner submits that he would not press this petition, rather reserve his right to agitate all the issues at the appropriate stage by resorting to appropriate remedy. At the same time, he submits that his client is apprehending arrest. He would surrender or appear before the court below on before 10th of January 2025 and move application for grant of bail. He subject to petitioner appearing before the competent court, and moving the appropriate application for grant of bail. No courtly action shall be taken against him till that day. And if the petitioner moves, surrenders and moves application for grant of bail, the same shall be considered on the same day, on the same day, on its own merit. Anyway, I have protected till 10th of January. Will you use? Yes.
Even the extension of my lord time.
Extension of?
Extension of time, my lord. I have already filed IA and you will also be directed state to take instruction. My lord.
Yes.
Yes, my lord. Process last one directed that the documents which he has filed with the
This is in reply to the submission report regarding the patient.
Page 2, the doctor. Then emergency surgery, but elective surgery.
It is not an emergency surgery.
Supravic lipid deposit, my lord. Is
not an
my lord,
emergency
it is
surgery.
required because on supravic lipid deposit, my lord, on the nerves are blocking, my lord. So you
Doctor says that it is not emergency.
no, my lord, it is you also passive to Mr. Sorting will agree this matter, my lord. Pass it over, my lord. You also pass it over, my lord.
What pass over election?
Mr. Sorting will agree.
What is the time? Oh, I have granted till
My lord, 2 weeks, 2 weeks you will be granted. Order letter 7
I'll give one more extension with a rider that no further extension shall be granted. Right.
2 more.
Petitioner was and main bail application is disposed of.
Dispose of, my lord.
Huh?
Dispose of.
In the present petitioner has moved application for extension of time to surrender pursuant to surrender after the expiry of the interim bail period. This court by order dated 7/10/2024 granted the petitioner to how much? 2 weeks.
2 weeks.
2 weeks.
2 months, my lord.
2 months interim bail. 2 months interim bail for a period of 2 months, which has already been, which is going to expire tomorrow.
My lord. Tomorrow.
Tomorrow. The petitioner has moved application seeking extension of the interim bail period on the medical ground. He has submitted a document of issued medical document issued by Edorn clinic. Edorn clinic by Dr. Hers.
And I mean, operation is on 2/1.
The document dated 17/12/2024 reveals that the petitioner has made certain payment for the advance payment for the surgery scheduled to be conducted on
2nd January 2025.
2nd January 25. Although the doctor has opined that the surgery is not an emergency one, but the factum of surgery has been factum of surgery fixed on surgery date has been admitted. It is that the Mr. Jana IPS for the state and submitted the instruction received by the Inspector of Police COW Bhubaneswar verifying the authenticity of the medical document. Regarding to the aforementioned, I am inclined to extend the interim bail period for another 4 weeks. Another 4 weeks.
2 months you will see. Had a
4 weeks, and it is made clear that no further action shall be.
Well, after surgery, the wound will not be
ঘোড়াঘাট শুকিবনি সর্জারি পরে
4 weeks, 6 weeks for the 6 weeks for the, yes.
8 weeks
No, no, after surgery you get 2 weeks. Yes. Take it, next.
54.
From 54, my lord, the petitioner is in custody since 21/1/24, my lords.
21/1/24.
Offense under section 302, but in the meantime, my lords, after filing of this bail application, two co-accused persons who are similarly placed have been released by the court below, my lords. On the last occasion, I had given copies, my lords. Lordship directed to take instruction.
Have you checked it?
Check case, my lord.
Jukka.
Alias Banchani. He has tied the leg of that deceased, and there are two tractor was ran over the body. That are Bhagavatta Pradha. So the persons who were there, Bernard on bail, my lord. One is on the ground of my lord, is a lady and having a small kid. For that reason, she was granted there. And another person was granted there. He so the allegations are that they are surrounding and assaulted by means of various weapons, but one of them has been illegal.
The main allegation is against Bhagavata Pradha.
Jukko is also there.
My lord,
Jukko was there.
Yes.
I'm appearing for the informant, my lord. My lord, they beaten the deceased so badly. Then after they drag a tractor on that and let her kill, my lord.
What is the role attributed to this man, Jukka?
My lord, the person, the Bhagavan Pradhan, he drove the vehicle on the body of the deceased. And the Jukka was present at that time with the co-accused person, and the other person, namely Sasikanta Pradhan, he was also accompanied to the act, my lord.
How many accused? How many accused persons?
Total 6, my lord.
Total 6 accused persons.
And the accused who has already been granted bail by the trial court,
My lord.
his role and the role of Jukka.
Same, my lord. So all were present.
All were present, but the one accused granted bail on the ground of that she is a lady, and another who granted bail, their omnibus allegation that's why
But
he
there was
granted.
no specific allegation against
No.
him.
The only person
But
who
Jukka
drove the
has a
vehicle.
specific allegation.
No, Bhagavata Pradhan. Bhagavata Pradhan has specific allegation. He drove the vehicle
But
over.
Jukka has
All are similar except Bhagavata.
just read it. Yes.
There is
साइकिल नहीं पड़ेला रिलीवेंट पर्सन आने प्लेस तापर भागवता ट्रैक्टर जार नंबर 700 लागला आसला सेमाने ताको गुडा उतर हम जानी मो मोटरसाइकिल बांधु टाकी भगवान दादा कोडे गला होगी ता पछरे आसबिली जुकु घर किछि दूर देखिली जुकु प्रधान घर सम्मुखरे पक्का रास्ता पर मो दादा भगवान तळे पडिछि जुकु प्रधान ता स्त्री झिल्ली प्रधान ता पुओ विजय प्रधान
Jukko Pradhan tied the leg of the deceased.
पहुंच पड़े शशिकांत प्रधान हाथ में कटुरी कुराड़ी ठेंगा इत्यादि धरी मो दादा भगवान रास्ता गड़ाई निस्तूप माड़ मार मो दादा पल्सर गाड़ी से रास्ता पड़ा मो दादार पड़ी निश्चय हुई रास्ता पड़ा जुकू दिस प्रेजेंट प्रिजनर वन ता स्त्री वो पुओ विजय विजय नॉट मो दादार गोड़ को बांधी रास्ता पकाईदे मो दादा अचल हो गला भागवत प्रधान ट्रैक्टर चलाई मो दादा भगवान
Active participation.
Malas, this person Jukka, malas, the person who has said he has not seen the occurrence. Yes, malas, then I'll withdraw, malas.
Withdraw and
I'll withdraw. I'll try, my lord.
Yes.
There are several eyewitnesses.
Yes.
There are
Next.
several eyewitnesses.
Yes, next.
I'll withdraw.
25.
Great.
Yes.
May please, my lord. Item number 55, my lord. But this is the case under section 20B2C, my lord. And the
He has to supply the deposition copy, but he is not.
Supply the deposition copy. First week.
Last order.
First week, second week. Yes, next.
56, my lord. Here the this is Raja in custody in 16/5/2024.
16/5?
2024. Here, alleged offences are 498.
It is not available, but my lord is filing.
Your Lordship, see. She
Have you read it? Ready?
She committed suicide by taking poison.
Okay.
And the husband in custody.
Your husband?
I'm the no, madam. I'm the sister-in-law.
Another group. I'll grant bail.
Yes, sir.
Right. Petitioner is accused in so and so case. Along with how many accused?
2 others. Husband and the.
Yes.
Let's see at page 8. The husband and the Jadi Amana referee.
Along with the husband of the deceased. The allegation against the petitioner also. The petitioner is the sister-in-law of the deceased. The petitioner is in custody since 16/5/2024. There is there any specific allegation against her?
No, but no specific demanding dowry or also deeply actually that is the allegation also. Very fateful day, the husband of the present Nageswara Mysore Nath is demanded and torture in that very fateful day.
There are how many allegations leveled against the petitioner in the FIR, and charge sheet in the present case has already been filed on. Charge sheet filed on? Yes.
Yes,
Charge sheet
see at
on
page 12, ma'am. It was filed on
16/5/2024. 24 for alleged offences punishable under section 498A, 294, 323, 304B, 306, 34. IPC read with section 4 of DPA. Regard being had to the fact that the charge sheet has been filed in the present case, and the petitioner is in custody from 16/5/2024. The petitioner is a lady of 28 years, 28 years age, and glad in large person.
Much obliged.
Yes. Next.
57.
But offense section 302, FIR was lodged against unknown persons.
Custody?
Custody since 8/10/2023.
8/10/23.
No.
Yes.
Allegation is that the deceased had left the home. He usually comes back to the house at night 9 p.m. He did not return, and the next day his dead body investigation was taken out, and it was stated that he was the last seen in the house of a miller's lady with whom the present petitioner had also miller's relationship. If you also the statement of witnesses miller's, that lady herself.
Here CD is required.
Call for CD.
Just now I talked with.
Last 3 occasions CD was called for. Even in the earlier application CD was called for, they are not giving the CD also. That's why Lordship granted me liberty to approach after the charge sheet. Thereafter I approach the after charge sheet. Thereafter it was.
How much time will you take to get CD?
In fact, just now, in.
You got it?
They will supply on Monday.
Then I'll keep it on for 24? 24. Yes. 24. He is getting today. Yes. Okay.
59.
Yes.
CD has not.
No CD. Call for CD.
Yes,
Yes.
CD has.
60.
January short date.
January. Yes. 60.
Second week.
May please, let's see, my bail application was allowed, but it is subject to verification of a similar antecedent. Last occasion, you will be directed to file an affidavit. Let's see, only one similar antecedent. Below commercial quantity.
What about that case?
That case I am already on bail.
What is the recovery in that case?
Small quantity.
What is that?
Brown sugar. Let's say.
How much you tell me? How much? What is the recovery in that case?
Let's say accurate below commercial quantity. Let's say.
Do you have any? Do you have any idea? Release on bail by which court? Nothing is written. By which on court? Where is that order? Order of the bail in that case?
Let's see that order with
verify. Let counsel for the petitioner submits that the petitioner has filed an affidavit dated 7/12/2024. The state council seeks time to verify the same. Release the matter January 1st week. Yes, next.
61.
Wait, please. Madam, kindly reference to the last order, madam, at page 5, where in view of the charge sheet has been submitted to renew the prayer, my lord.
Yes.
Yes, my lord. My lord, here the affair, my lord, was.
Charge sheet has been filed now?
Yes, my
Charge
lord.
sheet filed?
Yes, my lord.
Yes.
Charge sheet affair was registered on 30/10/2021.
Yes.
And
You are in custody since?
My lord, I am custody since 15/3/24. And charge sheet was submitted on 38/24, my lord, after 3 years, my lord. And that too,
FIR?
FIR on 30/10/2021, my lord. And on the basis of confessional statement, as we know, Tufan Singh versus State of Tamil Nadu, it is inadmissible, my lord. My lord, on the basis of that, I was nabbed, my lord. After 3 years, the final charge.
What is the recovery?
Recovery is only 197,900. That is the alleged recovery, my lord.
Yes.
Yes, sir. 97,900.
There is no conscious position.
No conscious position, my lord.
Kindly have a glance at page 29 in fact.
29.
Yes.
Yes.
The last few lines is relevant.
29. Okay. Yes.
During investigation of this case, I verified the seized Maruti Suzuki bearing number so and so and found that the registered number of the seized vehicle so and so registered in the name of one Trilochan Machi. On the cusp of this information and as per the direction of so and so, I conducted raid at the house of the owner of the vehicle bearing so and so. On interrogation, he stated that he had borrowed ₹2 lakh from a person, namely Hon'Ble Machi, the present petition. He bought the above said Maruti Swift car bearing.
And Ghanshyam Maji had taken the car.
Yes,
yes, my lord.
Yes,
So indirect evidence. Direct evidence is not. Right of petition.
My lord, I have another thing, another two incidents that is pertaining to 323, my lord. My lord, this is the
I'll pass the same similar petition. Yes, petition. The petitioner was not named in the affair. Not named in the affair. However, after investigation, in the charge sheet, his name is dropped in. The FIR was registered on after 3 years of investigation on 30 Act of 2024, the charge sheet has been filed. The petitioner was taken into custody on 15/3/2024. In the investigation, the following part of the charge sheet is extracted, which implicates the petitioner. Page 29, last annex. Last annex. During the investigation, during the investigation of this case, I verified the seized involved Maruti car. Last time. There is no direct evidence against the petitioner. The contraband ganja of 97 kilos.
Yes, my lord.
90?
199 kg.
197 kg.
197 kg. Has not been recovered from the conscious position of the petitioner. The only allegation against the petitioner is that the vehicle used in the transportation of the contraband ganja was in position of in the position of the petitioner, as he had taken that vehicle from the original owner in lieu of the payment of rupees 2 lakhs. Rupees 2 lakhs. Rupees 2 lakhs. The petitioner in the custody regarding head to the period of custody and nature of acquisition against the petitioner and the quality of evidence collected by the prosecution against the petitioner, I am inclined to enlarge the petitioner on bail accordingly granted bail. Yes. Subject to verification. Similar.
Bail granted.
You don't want, huh?
No, no, my lord, I couldn't hear. Grateful, my lord.
What happened in case, Miller?
present petitions are trusted villagers. Allegations against him that they suspecting deceased were involved in witchcraft, entered into the house, and committed this crime. My submission here, not a single eyewitness to occurrence, out of 17 witnesses.
Custody since?
Yes, custody since 26/9/23.
26/9?
2023.
23, yes.
My lordship,
Any
there is a dying declaration. Because there are
Read the dying declaration.
my lordship, that was mentioned in the
Yes.
my lordship, may I read the relevant part?
Yes. Oral dying declaration.
Yes, it is itself in the paragraph 3, my lordship, in the order. That no eyewitness to the occurrence, the informant and her brother who reached the spot after the incident, and they have not seen any of the accused person. That on receiving the affair, the investigation started and IO arrested all the accused person on the same day. That while investigating the case, the IO was seized 3 weapons of offense, 1 axe, 2 knives, which are different than what has been described in the affair, and he also not found any of the petitioner have assaulted armed with any weapon. That the affair was filed on the next day after more than that is the plea of the petitioner. Then my lordship, that the humbly submitted that the petitioners were falsely implicated and all the innocence of the offense in the absence of any eyewitness as per the investigation. That the prosecution has tried to build up the convocated case by the recording.
Come to the relevant part. Why
Yes, my lordship.
Do you have that dying declaration with you?
Yeah,
Read it.
dying declaration exactly not have, but my lordship, he has told to his brother that 164 statement, it is there, my lordship.
Read the 164.
Yes, my lordship. ମୁଁ ଆଜି ତାରିଖ 14/12/2023 ତାରିଖରେ ଉପସ୍ଥିତ କପିଳେନ୍ଦ୍ର ଓ ଶଶିଦାଙ୍କର ଜୋର ଜବରଦସ୍ତି ପଶିକରି ଆଗ କପିଳେନ୍ଦ୍ରଙ୍କୁ ଟାଙ୍ଗିଆ ଓ କୁରାଡିରେ ମାଧ୍ୟମରେ
This spot, my sister also ran to this spot. Cross examination. I cannot say specifically as to who told me about the assaulting incident. His PW2, another PW4. He was also at the time of incident with the.
It must be dying declaration, oral dying declaration.
Oral.
Yes.
No,
But she is not supported now.
No, my lordship, another one is Saraswati.
What is the name of this witness? Saraswati.
Huru Malik. I have read the Huru Malik.
Guru?
Malik. And another one is Saraswati Malik. All are saying.
This Saraswati Malik, I have read, he is the sister of the deceased.
But 164 statement, all have stated that she has told in front of
164 statement of how many people recorded?
Yes, my lordship.
How many of them are examined? Let us see.
4, my lordship.
Huh?
4. Yes.
Who are they?
Saraswati Malik.
Saraswati,
Huru Malik. Huru Malik.
Huru.
Santi Manga Malik.
Santi.
Yes, Santi, SANT, Santi Manga Malik. And another one is my lordship, Santosh Kumar Malik.
These all persons.
No. 1 minute.
Yes.
All these people were examined?
Yes.
All
Huru Malik was been examined. Who is not examined? Out of them. Santosh has already been examined. Huru examined. Who remained them?
One thing, my at my home, I saw my cousin Sasita was lying dead on the veranda. My house is adjacent to his house. She was residing at Talasai. I heard she was shifting in injured condition, Miller. I heard that. Miller. I heard that villagers were suspecting this is Kapilendra as a this is not incident, then recording lot, then PW 5 lot.
5 witnesses have been examined.
7 lot.
7.
Santimanga Malik, who was given the 164 statement, she has confirmed that the magistrate has taken as 164 statement and she admitted that this has done my
She has
lordship.
not yet been examined.
What
Yes, my lordship.
Where is it?
My lordship.
Who can have gone to?
Not Guru, Santi I am talking.
Santimanga Malik.
Yes, yes.
Saraswati has been examined.
Place located in the same village at the little distance.
Para 2.
Yes, Para 2, my lordship. We asked
Para
Sasi-
2.
Yes.
We asked Sashita.
Sashita that to who caused such injury. She told that the accused person, namely Budu, Chaitanya, Hemanta, Chandan, Mithun, Jalendra.
All of them.
And my
The
lordship, in
English
the
confirmed.
cross-examination I am reading.
Yes, yes.
Hearing south of my villager.
Yes, wait. How many witnesses are there total?
7.
7 witness examined. Wait. Renew after 3 months. Yes.
PW 5. We told the PW at the time.
Dying declaration is
No, what he said, my lord, that he denying, my lord, dying declaration given by the deceased before PW2, he denying, my lord. I am also there, my lord. No dying declaration there, my lord. All are
But Santi says.
in the cross examination, I have not seen, my lord.
Santi says.
His sister PW says.
Wait, 3 months.
One. No.
Yes.
PW 5.
5.
Yes. I heard about the incident when I was in my house at Upper Halman. I, along with informant of Saraswati PW2 Miller, rushed to the spot. But on the way, we met with the injured Sasita, who was sitting on the road, sustaining severe injuries.
Yes.
We brought to her house, laid her into the veranda.
Come to the injury.
Then it is not a fact that I have stated before IO that on being asked, the injured Sasita disclosed before us that her husband were in their house and accused person so and so being made to shortly killed them. Yes, specifically, it is not a fact that this person Miller, he is very much with the PW2. And one last commission Miller, there are more than 15 months inside the jail, and all are the docking villagers Miller.
Another
And
one
after
is
remote
to
villagers, the remote villagers, which is the submission Miller.
Come to the same witness which you read. Para 3.
Yes.
Para 3.
Yes. It is not a fact that
FIR was registered under section 307. That is that page 8, my lord.
Yes, I got it.
And
become 302 now.
Became 302.
Yes.
And your lordship also can have a glance over annexure 3.
My lordship, that a CD has not yet received.
Get the CD.
Yes, my lordship.
Let's say, in fact, your lordship has dealt all other persons.
And when it
But
is
it is direct allegation.
307, turn to 302.
302 ହେଇଗଲା ପରେ.
But therefore, the statement of the victim.
Victim ର statement ନାହିଁ. I have got the charge sheet.
Let us see, even 161 statement is dying declaration.
ନାଇଁ ତାର statement ହିଁ ନାହିଁ.
Then it's good. Then it's good.
I have the certified copy. If your lordship want to rely, can rely.
He was so severely beaten up. He was not able to give the statement also.
So severely in this sense, my lord. There are two FIRs. FIR 51, FIR 52. The incident took because of ଗୋଟେ କୁକୁଡ଼ା ଚିଆଁକୁ ଗୋଟେ ଝିଅ କୁଦି ଦେଲା. Both the family tussled with each other. This accused house was broken, asbestos were damaged, everything. This is on record, Annexure 3 I have filed. In the process, they assaulted this party and this party also assaulted. One blow became fatal. These persons have also injured, number of injuries, because that is not 302. All of them have been 438 released. And this person age is not much also. And April ରହିଲେଣି.
May I please, Your Lordship?
Get.
My Lordship, another thing is that another bail application was disposed by this Honorable Court, where your Honorable Court has directed that this Sanjeev Goda has direct involvement of this.
Who says no?
Yes, my Lordship. Other accused, my brother is saying other accused was released on bail because they have no direct.
He has given the blow.
I have whispered the word parity.
Yes.
Ma'am,
Yes.
please.
He says he's admitting that he has given a fatal blow, but it is not intentional. That's what he mean to say. It cannot be 302,
Yes.
maybe 304 part 2, whatever.
Yes.
But
yes,
there is
yes.
no direct money. He has had no intention because
No
there is
intention.
a free fight between
Free
two.
Exactly, my lord.
He gave a blow. Unfortunately, that blow has caused the death. That's
ये
what-
भी 5-7ଟା ଖାଇଛି କିନ୍ତୁ ହାତରେ ପିଠିରେ ଖାଇଲା ସିଏ ଗୋଟେ ମୁଣ୍ଡରେ ବାଜିଲା ଆଉ କଣ?
So there was no
feat of
intention
rage-
as such. That's what he.
Feat of rage, your lordship has
Yes.
written in that order. Anyway,
Yes.
Let him.
Yes.
can it be little early, my lord? If
He'll give it every day.
କାହିଁକିନା 10 ତାରିଖରୁ ଉଠିଲା 10 ରୁ 19 ଆଜି କି ଥିଲା ଯଦି
First week.
Yes.
Yes.
64.
Yes. 64. Yes.
Your Lordship, as per the noting, the AD has not yet returned.
Service complete. Huh?
Sorry.
Service sufficient.
Yes, Your Lordship.
Yes, service on the opposite party number 2 is sufficient. 2 or how many? Respondents. Respondents are sufficient. However, none will appear and parents. And hence in the interest of justice, simply adjourn. Yes.
65.
Yes,
Lordship,
madam.
and for the petitioner, I have filed an IA for the modification of order number 3 dated 18/9/2024.
29.
Order number 3, 18/9/2024.
Okay.
In paragraph 3 of the said order, it has been inadvertently typed after investigation, the police has filed the final form on 19/1/023. It's typed. It is instead of 19/1/2024.
Okay. 2019/1/2024 Court 80. Para 3 of the order dated 18/9/24. Okay. Okay. Hello.
Obliged, Lordship. We don't know.
Modification.
Final
allowed.
form has been filed.
Huh?
Final form has been filed on my affair. On this
Seeking modification. Yes.
modification in the sense
Modification of date.
or date.
Of the final form.
When this application should be dropped once final form is been filed.
Sorry.
Because
Today only the application is listed. The application I'm allowing, I'm correcting that.
Obliged, Lordship.
68.
That is the only allegation.
Yes.
Being the legal heir of the.
The cell deed was the father of this petitioner, my lord, and this petitioner had sold a property. Once to a
Who was the owner of the property?
owner is the father, my lord.
Father has sold the property.
Petitioner is the my lord, legal heir.
No.
Father has sold the property. He is the witness to the sale deed.
Not witness, man.
Huh?
Yes,
Where
is that sale document? Show me. Where is that sold?
the land belongs to the mother of the present.
You tell me, show me this sale document.
Sale documents is seized by.
What
the
is your name?
police.
The name is Sri Silpa Praharaj. Where is that sale deed? Show me the sale deed.
Sale deed has been seized by the police from the
Photocopy, you must be having the photocopy.
Sub-register office, man.
You must be having photocopy with the charge sheet they might have given you.
Fail to agreement is there, my lord. Agreement is there, no sale deed is.
Land counsel for the petitioner seeks an adjournment to file additional document to substantiate her case. Lease the matter after second division. Yes. Next.
My lord, online Mr. Dhar, this is after vacation.
Or simply on request, lease March.
Your 70.
Item 70, Lord, neither AD or on-delivered notice return.
In item 70, you are appearing for the opposite party note too.
Is already entered. What do you want?
Let's make kindly taken on next. After vacation, let's.
Only Pastor Mr. Amit Prasad Bose will be arguing for the matter, my lord.
Is opposing? Are you opposing or
Opposing, my lord.
opposing?
After vacation, let's my senior will argue.
Only.
Okay.
Interim let's content.
My lord, maybe date fixed.
Entered appearance for opposite party. Land counsel for the petitioner seeks an adjournment. However, the opposite party object to the same in the interest of justice.
My lord, in one thing, my lord, in this case, this is the FR 76-2N, my lord. Therefore. So if you also
petitioner are also willing to marry.
My lord, maybe call for the girl informant.
You are appealing for whom?
Opposite to my lord, informant, my lord. Victim, my lord.
Victim. Now, who is the informant?
Informant is the victim, let's see.
You are appearing, let us see. Yes.
Interim let's come.
Yes.
71.
My lord, our name may be reflected.
Yes, yes. Name.
Amit Prasad Bose. Bhagalan file age.
Yes.
In this case, you are also fixed on 17th for final adjudication of the case. Notice already issued to the informant of the state. And in the meantime, my lord, the warrant has been issued that may be stayed till next date. That
service complete.
So there is option there for final adjudication.
Where?
You'll also
Connected matter. Connected matter.
No, this case was adjourned to
17th. Why it is listed today?
Is it that warrant has been issued?
He has not appeared, my lord, but only warrant has been NBW, my lord.
NBW issued. That I have annexed the interim application.
Where is that?
That is
the interim application.
Yes.
Bag X.
Yes. Authority to the yes. That it is pertinent. You understand that it is the economic offense. You also is the driver. That's
in this application, the in the CRLMC, the main CRLMC is listed for hearing on 17th January 2025. Due to the absence of the petitioner in the proceeding, in GR proceeding number 190 of 200 2021, the learned JMFC Boringuma has issued NBW against the petitioner. He seeks, he is aggrieved by the same and has moved the present miscellaneous application, present IA. The execution of NBW issued by the JMFC Boringuma by the order dated 18/11/2024 shall be kept in abeyance till 17/1/2025.
72.
Said application was about to be taken up on 11th December, madam. On that day, it was in serial number 72.
For the reasons stated in the application, the date of hearing fixed on 4/3/2025 is preponed to January date.
As it is 91 application, lordship.
It's not possible. I am January
day,
first week. Yes.
Any day.
I will allow January first week. Yes.
On 23rd, lordship, I request.
23rd, 24th will be like that only. Same thing will happen. That 2 days hearing, I don't think.
3rd of January.
Better that you first week is better for you.
3rd of January.
Yes.
74. May I please?
The petitioner, my lord, quashing the proceeding on the relying the decision of the Upasana Mishra case, my lord, wherein notice of omnibus demand, my lord, in 16 lakhs, the check bounced in 4 lakhs in 2 checks. And the reported in 2024 one OLR Supreme Court 485.
Yes.
And the check is 19 page, running page 19, and the running page 22, my lord, the 16 lakhs. The check is 4 lakhs, my lord.
Show me that.
Yes, my lord, 19 page, running page 19, your lordship.
19?
19. Check is 2 checks, my lord, 2 lakhs, 2 lakhs, 4 lakhs, my
4
lord.
lakhs. Yes.
22 page, my lord, in the notice, my lord, demand notice, it is 16 lakhs, my lord. Requested to 16 lakhs. ଦେଇଛି ଷ୍ଟେଟକୁ ପାର୍ଟି କରିଛି ବୋଲି କପି ଦେଇଛି।
You read page 23.
My lord.
16 lakhs. Checks is been issued and
You read half of it seems.
My lord.
16 lakhs, you paid number of checks. Out of that, 2 checks were presented. These 2 checks were got denied. Frivolous, complete frivolous case.
That is
why unnecessary of misleading statements.
my lord, and another, my lord, a second point is that, my lord.
No, first one you concede that you have misled.
No, I am not misleading.
Why are you trying to mislead? You read it. You said that 16 lakh checks, 16 lakh demand notice, 4 lakh check. You issued many check. Out of that, 2 checks he had represented. And two check, 2 lakhs, which got degenerated and he issued notice. What is wrong in it?
My lord, another aspect, my lord, is check in the name of the partnership firm, my lord.
Oh,
In
those things-
141, my lord, they have not added as an accused, my lord.
No.
Your lordship, in 2 checks, my lord, 1 notice, they have stated in entire amount, my lord.
Whatever these things are.
That is your lordship
No.
notice, your lordship.
No question.
Your
If
lordship-
you would come and clean hands, then I would have interfered.
Yes, I have annexed that, my lord.
Petitioner is agreed by the order dated 5/11/2021 passed by the letter SCGM Raigada, taking cognizance of offence punishable under section 138 MIA for against the petitioner. I have learned counsel for the petitioner submits that although the petitioner has issued petitioner in the petitioner in the demand notice has categorically mentioned regarding the due amount of 16 lakh. However, 2 checks of 2 lakhs have been presented in the bank, which eventually reasoned. But perusal of the notice reveals that the petitioner has issued a couple of checks out of a couple of checks to discharge his liability towards liability of 16, out of which 2 checks were deposited by the petitioner in the bank, which were returned Therefore, the petitioner has initiated the prosecution against opposite party has initiated prosecution against the petitioner under 138. I find no reason to interfere in this petition, hence it is dismissed. Yes. Next.
76.
May I please?
Yes.
This case, my lord, though I have filed case for a day of conviction, my lord, but in fact, your lordship earlier also said that the matter of final disposal since paperwork has already been prepared, my lord. That is available.
I'll fix it for hearing.
Small matter today, my lord, 5 minutes I will take, my
It
lord.
will be posted for hearing.
Hearing,
As
sir,
your
5
lordship
minutes.
says. Is it a draft case? It is
It
a draft.
won't take 5 minutes. Appeal can't be.
Only
You may take 5 minutes, but Mr. Das.
two tests only, my lord. PW 9 is the complaint. He did not support the case at non-hostile.
All others are
PW 3 the overhearing witness. He stated that he was standing outside and door was closed and glass door, my lord. He has not hearing the converse. What is the conversation between the
Reply করনি reply করনি কি appeal name it reflecting because list non-APS for opposite party number 2 this non-APS for opposite party number 2 is the matter entry mode to continue yes entry mode to continue.
Oh, bless. 82.
Your lordship kindly pass over. Your lordship short
password 330 password.
Lordship short pass over. One password. Lordship.
On the request of for the petitioners, please the matter to mode to continue. Yes.
53.
I'll give the brief backgrounds of the case and then I'll tell the case law.
Yeah.
One Sachidananda Mahapatra is the complainant. Now,
what was the last order? Let us see.
For final disposal. Stay has been continued because of the Supreme Court order.
Request for extension of interim order is granted.
Yes. Because of the Supreme Court indulgence. And that has been continued and for final disposal today. So I'll give the brief background, then I'll take you through the relevant documents. But Sachidananda Mahapatra is the complainant who states that believably he has deposited 20 lakh rupees to buy some plots. He clearly mentions in the FIR that this amount is the security amount, but not the full return. So out of 20 lakhs, which he has deposited to begin with, somehow or other, the land could not be collected. We couldn't have it in proper flood. There is no agreement, in fact, that has been signed with the Sachidananda Mahapatra. He is the sole complainant. And he says, I visited the place, got myself satisfied with the project, and then deposited this money. So to that extent,
who are you? You are.
I'm the accused.
You are the developer.
I'm the developer. I'm the managing director and directors. Both of them are here, including the company. Now, my lord, there are three facets which have come out clearly. We'll read that FIR together. That I didn't pay the entire consideration of the money, only the security amount, which is 20 lakh. I went to the office and became satisfied.
After due diligence, he is satisfied and paid the part of the money.
Yes,
part of the money.
Part of the money,
yes.
Not the entire money.
Yes. And there is an agreement to that.
There is no agreement. It is his own case that the agreement was not executed with me. And then, my lord, there was some delay that was occasioned. Land could not be arranged by me. I volunteered that out of 20 lakh that you pay, take 4 lakh cash. He accepted. 16 lakh rupees was the amount that was given in check, which ultimately was bounced. And he goes against me to the lower court with 138 proceedings. That's pending. Against that background, my lord, instead of pursuing that 138, he goes to the crime branch because he knows somebody in the crime branch. Crime branch, my lord, invokes section 6 of the OPID against me, even though Section 6 of the OPID was not in the statute at the time when the FIR was lost. Please take note, my lord, two dates, important dates.
FIR is 3/6/2013.
3/6 of 2013 is the FIR. And the OPID Act came into force on 12th of August 2013. So Section 6 is invoked because of the only defense
in the charge sheet they invoked
they invoke Section 6 against me, which is a draconian legislation. It's penal in character. It couldn't have been
then what did you do? You have filed any application before trial court or what?
No, right. Then I challenged the entire proceedings before you. I got a stay to begin with, and the matter is pending here.
Okay. Yes.
I was granted bail, but if I can take out some of the case laws, my lord, Section 6 is
6 will go.
Yes,
Obviously,
it has
6
to necessarily go. There are two judgments, I'll cite it.
Yes, what do you say? 6 has to go.
No, my lord. What happened, my lord?
See the date of FIR.
Yes.
Date of FIR is 3/6/2020.
Yes,
13.
that is true, my lord.
That time it was not even born.
That's right.
My lord, two judgment of our own High Court, my lord. These are the continuing offense, my lord. I'll show that to
No, I'll deal with that. No, I'll deal with that before you are called upon.
Yes.
The only argument which seems to have been made by the prosecutor is that this is a continuing offense. Taking one line of Justice B.K. Naik's judgment, I will quote it just now.
It could have been a continuing offense if the money, a transaction, the trail goes on. It is an isolated incident of 20 lakhs paid or not. And the offense is done that day and it's gone. Everything gone.
I'm grateful.
Where is the question of continuity?
998%.
Until he can keep that money, he will continue.
Total 998% are there, my lord. He's not one, my lord. Kindly look, para 7 hour affidavit.
No, maybe let me complete that continuing offense drama which you have enacted before Justice Naik. My lord, continuing offense means in law and in simple terms. Primarily, my lord, these are all applicable to the matrimonial cases. But here, what they seem to suggest, which has not been in fact appreciated by Justice Naik, that it is a continuing offense which would indicate that supposing, my lord, OPID Act is already in force, I commit that offense today. So till such time this offense continues, because of this continuance, it will be a continuing offense. It cannot be a continuing offense which in a retrospective manner.
Insofar as the other complainant are concerned, it may be a separate offense under Section 6. But so far as this complainant is concerned, Section 6 will not.
Number one. Number two, my lord, the other complainants, my lord, the prosecutor is holding.
I'll bring that judgment and that day will be.
You don't have to bring the judgment. I have brought it just now. I'll show that continuing offense.
Yes.
The drama that you people have created in the courts. My lord, please see.
Don't say that you have created in the what we have created.
No, don't say those expressions are not required. Argue on merits.
Correct. Well, the continuing offense actually, my lord, does mean that if the statute is already there in the statute, and then I continue that offense, till such time this section is not invoked against me, then it would continue to be enforced.
Yes.
It's not a matrimonial litigation. At a time when the FIR was registered against me, obviously the statute was not there and invoked me against me. And my lord, as far as my friend saying that the lot of complainants are there, he is completely, my lord, wrong on facts. I'll tell you how. The FIR is registered. Please see the FIR copy.
Yes.
But it's page 19. Is registered by one individual called Sachidananda Mahapatra. Kindly see page 21. Ame Sri Sachidananda Mahapatra, and at page 25, the signatory on 3rd of June 2013 is Sachidananda Mahapatra. He may have brought some names inside, but they are not the complainants. So there is a distinction in law with regard to naming some individuals by one name, and you are making them as witnesses in the charge sheet. So it's witness, my lord, in the charge sheet and a complainant in the FIR are clearly distinct characters. So my friend
any of other investor, those who have been cited as a witness to this proceeding, have given you complaint? Have you received any complaint?
Answer is no.
That answer, I'll answer, my lord.
See, I'll tell you, if separate complaints are being filed by other investors, you can register separate case. You invoke section 6, no problem. But insofar as this complaint is concerned, the day when he registered the FIR, that day in the statute book, it was not born. The section 6 was not there. So, insofar as this FIR is concerned, section 6 cannot be invoked because it can't be continuous offense because he might have cheated many people. There may be separate cases, no problem. You invoke section 6, whatever. But you can't say in this case it is continuous.
What I'm submitting, my lord, during the course of investigation, my lord, this
You found XYZ thing.
No,
Separate case you registered.
Opioid Act came into force, my lord. Subsequently, 100 investors came, my lord.
But then separate case, you can register separate case under section 6 and proceed against him. No problem. No problem. Suppose 173.8 is open. Tomorrow some other legislation comes. Again you will invoke those things. In the same FIR. Saying that it is continuing. It's not possible. Not possible. You have to try to be fair and tell. When the FIR was registered that day, this was not there.
More than 1,000.
Maybe you said register separate case, do whatever. That's what I asked specific question. Whether any of the investors subsequently given any complaint to you?
That from the I
then you should you should have registered separate case.
Yes.
And invoke 6, whatever you want to do, do it. But insofar as this case is concerned, 6 you can't invoke.
But my friend is not ready. Another story, but his answer is here in the charge sheet.
Otherwise, also is not ready, seeking adjournment.
Yeah, that's right. His answer is in the charge sheet.
I'll just put it for hearing and interim order to continue. Interim order to continue, and you have to answer this.
Yes, yes.
Good answer.
Here, predicament, my lord. Suppose 1,000 investors are there, my lord. Against one person, section 6 open will pass. Or rest 99 will go, my lord.
No, you do whatever. You do whatever. But in so far as this FIR is concerned, see, investigation of what? Investigation of an FIR. A continuation of offense, this accused has to be seen, not some other accused, some other this thing, complaint. He has cheated X. That transaction, you have to see whether continuity is there or not. Or some other complainant, how can you bring him?
Call them to your office, entertain them, collect money, and
you do, that's their problem.
That's right.
That's their
problem.
Entry want to continue and the further argument, keep it for further. Okay. Just examine it. And
but let's say that he has short an adjournment.
Mr. It's neither here nor there. You are entry order is continuing.
Entry order in any case will continue.
Yes. Continue. Okay. On the request of the counsel for the OBID, lease the matter on such and such date. The interim order passed on.
Millard, my lord, senior also.
Yes.
Mr. 5,50,000 they have taken for the.
It's all right. Let him address next time. I'll just put it. Yes. So, entry order pass on 21/11/2024 shall continue. Yes. He'll give a date.
Yes.
Okay. Yes, next.
He's giving a date.
24.
Dead.
84 that matter lordship the IICP police the petitioner informant the solicitor police has lodged an FIR to A Visakha in-house committee is exonerated and thereafter FIR loss against this statement is recorded. 376 has been proceeded as against the matter. Taking up classmate. Last my knowledge in applying for
Mr. Palit was appearing. Accordingly, my lord, we have concluded our argument and we have also filed our written notes of submission and memo of citation, my lord. It is the time for the response.
No, the complainant has to answer.
Mr.
At least it in January 1st week. We'll see. Yes.
My lord, what I may be permitted to say, Mr. Palit has already in both.
That's right. I am waiting for Mr. Naik to answer.
Both the parties has already argued on 7th of December, my lord.
There was something to be addressed. Something. January 1st week. Yes.
85.
I have already filed my one system technology or
it's Monday, my lord, agreement has already concluded.
24.
330 matter will wait.
24. Yes.
330 matter will not wants me to wait. 330 matter.
Which one?
That Srikant Mishra. matter. On the back.
How many matters remain? Miscellaneous matter.
Therefore, my lord, indicate last occasion that.
Huh?
They are supposed to be giving me, and I'll sum up in 10 minutes.
Who is appearing from that 330 matters?
He is supposed to be giving.
And I have already given the CD along with the. How it can record as the investigation was on. I report from the evidence of.
Which matter? I forgot.
No, this matter correlates to that from 5.47%, it suddenly became 38%. And that regarding that.
And I asked you some questions.
Yes.
Regarding whether.
Even the difference, how difference occurred. As submission before your lordship is, your lordship may kind of a glance to pay.
Then give me 15 minutes, I'll just run through the list. So that the other people are waiting.
Yes, I have no problem, but I don't.
Just I'll run through the list.
Yes.
And wherever there is an adjournment, I'll adjourn thereafter. Because all of them are waiting. I'll just run through.
That 82 item 82 was passed over.
Adjourn, no pass over. Just see at 3:30 you can. If you are so busy, you enjoy.
Extremely sorry, Wala, I was held up in.
It's all right. Vacation after vacation, enjoy your vacation.
Yes. The entry model was there.
Entry model content. Yes. Yes. Let us run through the list so that wherever there is entry model, continue and list it out. Okay. Yes. 80.
They are filed an affidavit admitting the payment.
My lord,
Paragraph 9.
on the last occasion,
Which matter you are talking?
85.
You are talking about 85 or 86?
85.
85. Okay.
Paragraph 9 of the counter affidavit they filed today.
85. Okay.
Providing from Metro Milo where 84 matter 86 case was filed and the payments have been made in the meanwhile. 91, 92, the last payment was outstanding, that's as per their letter, and that is admitted in paragraph 9. Paragraph 9.
Paragraph 9 of
their counter
of their
affidavit. Last two lines, my lord. The document given in Annexure 5 and 6 are admitted to be of answering opposite party. 5 and 6 is the last payment of 17,000 something, which I have paid.
where have you read 5?
Yes. Paragraph 9, last two lines.
There is 6. The affidavit only is of para 6 only.
Sorry, man. Counter affidavit of their.
Additional affidavit or counter affidavit?
Counter affidavit. I am relying upon their counter affidavit. Man.
Yesterday it was filed.
It is not there on record.
Lordship may just have a glance.
It should come on record, then only I can rely upon it. Yesterday, little file little earlier. I'll put it on 24th. First week of January.
24th.
First week of January. 24th may not happen. 24th will be a tough day. First week of the 3-4 6th of
January.
Yeah, 6th.
Oblige.
Yes.
Land
Council for the opposite party submits that he has filed the counter affidavit yesterday, which has not come on record. Hence, leaves the matter on 6th of January. Yes.
Interim order to continue.
Interim order to continue. Yes.
Oblige.
87.
7.
So, I have filed the petition for pursuing of the provisions for 406. Both the parties have been separated since 2012. Both are minor consider engineering. I pray for time because I will write some document that she is now residing in America. And
you are repeating?
Appearing for opposite part number.
What do you say, sir?
Both the cases, CP case was challenged before this Hon'Ble High Court. That is pending before the Honorable Justice.
yes, ये divorce का time तो divorce का time तो वो divorce का अलग होएगा ତାଙ୍କ divorce ପରେ
He's
order
taking ex parte order.
ଇଏ divorce ହେଇଯାଇଛି ଆଉ ଏଟା କଣ order
He's
ହବ?
taking
ସେଇଟା
ex parte order.
No, you simply tell me whether you are going to contest the criminal cases.
I am going to contest.
Then adjourn it, interim order to continue. Yes,
So the first week of the January.
we'll give it. Okay. You keep on fighting unnecessary, nothing will happen. You are staying somewhere else. She is staying somewhere else.
Yes.
Why don't you settle and finish it up? Then what do you want from her now?
The question is on documents there, sir.
Oh, ठीक है. रख दीजिए February. Interim order to continue.
Sir,
Yes.
first week of January.
He will give. What is the urgency? Interim order is there.
89.
Time may
In the
heal everything else.
Early disposal in that.
It's also
We pray for.
ଯେଇଟାରେ ସେ wife ଇଏ ନୁହେଁ ବାପା କହୁଛନ୍ତି ପଇସା ମତେ ଦେଲେ ମୁଁ କମ୍ପ୍ଲେନ୍
ଦେଇ ଦଉନାହାନ୍ତି.
କାଇଁ ବାପା ମତେ ଦିଏ ନା
That is totally wrong, Miller.
ବାପା କାଇଁ
I have not told anything.
କିଛି ତ ଦେବେ maintenance ପାଇଁ.
ବାପା ଶଶୁରଙ୍କୁ
ନାଇଁ ନାଇଁ.
ଝିଅ ତାକୁ ଝିଅ 5 ବଜେ ରିଜେକ୍ଟ ଷ୍ଟାର୍ଟ ହଉନି
That is semantic shirt.
89.
Proceeding lower court proceeding has been stayed, my lord. That's a 138 in a act, right?
What is this case? Let us understand.
Sir, this is 138 proceeding, my lord. I am asking second item, my lord.
You are the informant.
Yes, ma'am.
What
But-
is
but the
this
complaint-
case?
For the purpose of, my lord, purchasing land, my lord, we have issued 25 lakhs to the now accused, the petitioner. And he has issued a check. So we are presented. Check at dealer. Now he is saying that the check has been lost in somewhere else. We have lost the FIR. Possession time that is pending. But in the last first order, the lordship said, first order, data cutter.
It is dated 17/3/2020.
17/3.
2023.
23.
Yes.
On that basis, this honorable court has granted stay.
Yeah, there is a possibility of amicable settlement.
The coordinate bench has given it.
Yes,
Yes,
yes.
my lord.
Now he is saying that he has not issued the check, neither he has known me. Check was lost in somewhere else.
So you had made a statement that you will settle the dispute.
As your first of all,
I'll send it to mediation and continue. Right now, on 17/3/2023, the coordinate bench of this court had issued notice to the opposite party on the opposite parties. The notice after notice was served, so and so entered appearance. There was an interim order of stay of further proceedings in ICC. Case number 284 of 2019, arising out of a complaint under section 138. The counsel for the opposite party submits that because of the stay order, which is operating since 17/3/2023, the 138 proceeding initiated by them against the petitioner is stalled, despite the fact that the statute, despite the fact that section 143(2) of NI Act mandate for disposal of these type of cases within a period of 6 months. Be that as it may, the interim order was passed by the coordinate bench on the ground that there is the petitioner had made the statement that there is a possibility of amicable settlement in the initial matter. Regarding head to the statement made by the petitioner on 17/3/2023, and the opposite party have already entered opinion. I feel it appropriate to refer the matter to the High Court Mediation Center, awaiting mediation report. Is the matter on the second week of January, and the interim order passed on 17/3/2023 shall continue till the mediation process is completed. Yes.
Sub item and the same matter, another check.
Same.
Similar matter, same, same, not dead. Same thing.
Yes, sir. I have sent it to mediation because you made the statement that I'll settle it.
Yes,
Now
yes,
settle
yes,
it.
ma'am. Yes, ma'am.
Yes.
90.
The sub item and same order. And
Yes.
the complaint case number.
Yes, yes.
Right.
We record though. Yes.
please, madam. So this is
Case number 4 into CRPC, I shall be arguing on 2 points. First, this is a purely civil dispute, given a criminal color. First point will be, and second will be that on the face of the issue also, the section 380 under which I am being summoned is not made out. I just going into the background of the case actually. What is this?
457 and 380. What are the allegations? Let us see.
No, I'm just going into because background will make it a little clear. I'm just in 2013.
For
I purchased a
the
car.
opposite party number 2 in this case.
In 2013,
you are appearing for
opposite party number 2.
In 2013,
This will be
I purchased a plot. The plot has got 2,700. It was 990 square feet of constructed area, and remaining were free. In the sale deed, there is a clause that I can construct in the remaining area also. And I constructed after taking necessary permission from the RDA. Even the owner, he also supports me by giving because he is the actual landowner, his signatures are necessary for some getting the permission to do.
No objection and all.
So applying for RDA, and he had supported me at that point of time.
Yes.
The construction was completed in 2019. But after 2019, that dispute started between me and the original owner. Original owner actually wanted that I should sell the plot and he should also get some money.
Who is opposite party number 2? Original owner?
No, not original number. He's something, but I shall come to him. He comes in something later, much later. Then in 2021, I file a civil suit seeking injunction that he cannot come into my flat and disturb me.
Injunction against the original owner?
Against the original owner. The Goenka is the original owner, Manmohan Goenka. The civil suit is part of this record. Then the original owner in that civil suit files an IA seeking an injunction against me, saying that I have constructed a iron gate. He is not allowed to enter into the premises. And second, he says that I am preventing him from enjoying the joint areas.
Yes.
In that actually, the learned civil judge, what he does, he says that dismisses that IA, saying that prima facie I am in possession, and if the order is passed against me, even if he has got some right or whatever may be in a civil case, then I shall be at disadvantage. So that case is dismissed.
In your suit, he can't move application and get it. Yes.
But that is not the finding. Finding is that I am in possession.
Next.
I am in possession. It happened in March 2022. After March 2022, then what he does, in order to put me into more trouble, he sells this flat to somebody else with no right to do whatsoever. And this party number 2 is the subsequent purchaser.
He is the least present purchaser.
Actually, he admits that he knew about the case. I shall go into his actual
Least
purchase.
No, I'm sorry. Little misleading statement is being made. So far as this property is concerned, he has not purchased at all. There are video clips, everything has been seized that will show that this kind of activity has been committed, which has attracted the criminal liability. So
Okay, sir, let us see. Let him complete.
What is to be seen is whether there is a prima facie case or not. He is saying that these civil suits and everything, as if the possible defense will be taken into consideration for the purpose of acquitting him. So that is what, my lord, I am objecting to, because he is projecting as if, my lord, I am just a rank trespasser.
That is my case.
Okay, sir. Thereafter, what happened?
He purchases. Then after that purchasing error, actually, what he does, he might have some civil right against me or whatever may be. He didn't pursue that. He files a complaint saying that I have committed theft from the premises which I am in possession. He has kept some glazed tiles and some property.
Show me the injunction order.
Injunction order. Yes, injunction order is in page number 70. Page number 70.
70. Yes. This injunction order is in operation even today.
Yes. It is still
pending.
It is still in operation. It is never been challenged. Nobody has challenged it.
Yes.
It pays 74 actually.
74.
I'm just going into the last part actually of the order. It seems that OP is in possession. OP, I am the OP in his application. In his possession, if the order of injunction is refused, the petitioner will suffer any loss rather than at this stage the opposition OP will suffer irreparable loss which cannot be compensated in terms of money. Considering all above facts and circumstances and for the interest of justice, it is for my considered view that the petitioner or the defendant has failed to attract any condition of the equitable principle of law in the injunction and it is ordered. The IA has become dismissed.
No, his IA is dismissed.
His
Where
IA
is-
is dismissed.
Where is injunction in your favor?
No, I have filed one injunction
The
order.
suit is pending.
The suit is
Show me the prayer of that suit.
the prayer that is in page number 65, page number 65.
65? Yes. Yes.
Actually, my property I am just telling page number.
Property schedule is
Property actually starts from 64, 65.
Same property?
Same property.
Yes.
I'm just actually 65 is more important. The plaintiff has made extension and the construction about the fourth floor and converted the entire fourth floor into a single dwelling unit, which is in exclusive possession of the plaintiff and described as under.
Where is that document by which he has purchased?
That what he has purchased, he has not supplied to me. I don't have that document. I have the document I have purchased. Actually, I'm just going.
Yes, Mr. Mishra. How have you come into the possession of this? He has purchased it. He has filed a civil suit, and the original owner moves an application which is turned down.
I'll clarify your lordship so far as this property which I have purchased in 2022.
I think you should, you people should settle the dispute. The allegations are very.
Keep it to after vacation. I will file the documents. But he is annexing documents relying upon things which he possibly should produce as a defense. I'll assist your lordship.
Why don't you settle the dispute?
My question of settlement, he has to settle because he has no right over so far as my purchased land is concerned. I will demonstrate from record.
The scheduled property at page 65, just see.
I'll show the comparison vis-a-vis my sale deed. I'm online. I'm unable to do that, my lord. Your lordship may fix it to after vacation. I'll assist your lordship, my lord.
Okay, I'll fix it for. But in the meantime, you both of you explore a possibility of settlement. I'm sending you to mediation.
I'm just one.
Allegations are minor allegation. Civil suit is pending. Why are you
One document actually why it is not made out. I shall come to that. Actually,
today I'm not going into all this thing. I will just send it to mediation, explore the possibility. Then I'll hear it. If you can't mediate it and mediation is unsuccessful.
One more thing. Actually, the original owner has also filed a criminal complaint against me. This honorable court has already quashed that one. This honorable court. Because
this one or not.
I heard.
Madam, may I one page actually, page 43.
I will continue the interim order and I'm sending it to mediation. Try. If it doesn't happen, then I'll hear it. No problem.
Oh, bless.
Yeah, that's what I'm saying. Heard at length. And heard Mr. Pradhan and Mr. Lee. Heard at length. It appealed from the allegation and counter allegation by both the parties that the dispute is arising out of a is a flat or what is that?
It's flat. Fourth floor.
Flat.
Purchase of flat and purchase of flat. And civil dispute regarding the same is also pending. Pending before this, where? In Bhubaneswar?
No, in Raukala.
Pending before the civil court in Raukala. I am of the considered view that the parties in the present set of facts should explore the possibility of settlement through mediation. Hence the party. Raukala, I'll send it to Raukala only.
Yes.
Both of them are Raukala?
Yes.
Therefore, the matter is to Raukala mediation. So awaiting the mediation report, the matter on circumstances And in the meantime, the interim order passed earlier that continued. Yes.
Obliged.
Explore
My
the
lordship-
possibility it can happen.
Obliged.
You have to fix in date for appearance, my lord, I missed it.
But the coordinator will issue the notice to you.
Right.
Yes.
Thank you to.
Any date for this court, any date before this court?
92. Yes.
That matters a lot. 91, my lord, favorable mediation report has come. 91, I'm saying, my lord. Favorable report has come. The next date of the mediation is 6 to 7.
Seventh.
Yes. 7. I kept it 8th or 9th. 9th.
Yes.
Is there interim order?
Yes.
Published.
Well, 92 is that matter where the lady's interim maintenance has been upheld to the Supreme Court without modifying or altering that order. The execution proceedings have been stayed. She is unable to get any maintenance. Decree of divorce has also not been finalized. It's pending in first appeal before this honorable court in the matter. And my lords, the money has been stopped to her.
There is no stay.
My lords, the execution proceedings have been stayed. That is
Okay.
why he's not making any payments.
Yes. Who is appealing for a police court?
Mr. Bose. On the last occasion also, your lordships were not very well.
The same thing where this is the matter where divorce has been granted and
Divorce has not been completed. It is pending in the first appeal.
he's scared of you. He's scared of you. Yes.
Here, your lordship may call it in the reopening of my, I'm unable to speak properly.
Okay.
Sir,
Because there were 3 matters before your lordship. So that I could-
sixth.
Sixth.
And sir, matter है detag है जो matter
Okay.
7th, your lordship, because 6th, the election case has been.
Yes, yes, 7th. Okay.
ठीक है.
Okay. 7th.
Interim order to.
हाँ ठीक है सर माटाटा detag है जो सर माटा सर आमे ताकू भी उठे पारनो कहना हमारा ये टाइम फाइल
Mata, who is tagged? Mata is not in my.
It was on my plate. Let it come on 7th.
No, Mata is the appeal is division bench appeal.
pending before the division and bench. And what is happening? No final.
See, retake Mata, call for the record on that day. Only you will call. Retake.
Right.
Hearing can't be.
Mata cannot be listed in 2 days. Let it be on 7th.
I see. I can't hold up the division bench file like this.
Some findings I have to place.
That's right, but I can't hold up the file of division bench. It should not have been tagged.
Yes,
my
It should not detag. Division bench matter. How can I bring and tag with this mark? No, I can't do that.
For reference on my prayer.
You can call for the record. I'll summon the record. That's a different thing. Detag and list all Mata matters. You can't do that. I have not. Have I asked for tagging?
Yes.
Call for record.
No, your lordship had on.
No. Where is that order?
There was an entry order.
See, lease the matter along with the Mata so and so.
Yes.
It should have gone to division bench then.
Yes.
My matter should have gone to division bench.
No, your matter, your lordships are hearing.
It is a single judge.
No, detag.
Obliged.
Interim order to continue.
This is not properly, worded this proceeding. I said tag is not exactly tagging. Actually, call for the record to just see that. But I can't bring the files of division bench. Immediately I'll be able to retake. Inadvertently by the order dated 5/12/2024, Mata number so and so has been taken with the present file. Detag this matter. Detag methods is directed to yes. You bring the files, whatever.
I'll give the order sheet. Lordship, interim order to continue.
Interim order to continue.
Obliged.
93. My lord. Company had issued a check, my lord. Company is not a party, my lord. Your lordship last occasion, your lordship directed the opposite party number 2 to verify the judgment, my lord.
Yes, my lord. I have gone through the judgment. Is in absence of company, it's not mental. It's kindly pass order.
Well, disposing of.
Yes.
Petitioner is seeking causing of the order dated 7/12/2015, passed by SDJ in Bhubaneswar in ICC case number 2966 of 2015. 2015, initiated by the opposite party number 2 against the petitioner. The petitioner is seeking quashing of the FIR only solely on the ground that although the check was issued by
Ma Santoshi.
Messrs. What is the name?
Ma Santoshi Ma.
Huh? Ma Santoshi?
Joy Santoshima Infrastructure Private Limited.
Joy Santoshima Infrastructure Private Limited, but without impleading the company as an accused, the opposite party has is seeking. Have I written opposite party has proceeded against the present petitioner who is the director. Director is one of the director of the said company. He has relied upon the what is that judgment?
2012 5 SCC 661. Onita Hada versus Godfather Travels.
The law in this regard is no more res integra. It is settled that without impleading, without arraying the company as a party to the proceeding, proceeding under section 138 the director alone cannot be prosecuted. Next one, so and so entered appearance for the opposite party and submit and conceals this position of law. Hence, the petition deserves merit. Accordingly, the ICC case so is cost.
Just cost matter.
He concedes your case. What to do?
Madam.
Yes.
94.
Please, my lords. The order passed by the First Appellate Court under annexure, my lord. 9. He challenged it for my lords.
Is there any urgency in this matter?
My lord.
Is there any urgency?
No, no. Urgency means at the time of admission, I had made a suggestion before my lords. Lordship directed, yes, let them appear. Thereafter, the order will pass. I am for the husband. The husband is all along interested to take his wife and son. But the wife so
service, what about service?
Service is he is serving Border Security Force. He
notice has been served or
yes, yes, notice has been served. They have appeared.
Any
day, if my lords will fix for conciliation before High Court, not my ones, because the petition is threatened by the father-in-law. So any day or a reopening, if your lordship will fix the 3rd or 4th any day, then in their presence, the matter may be referred to conciliation. Because the petition doesn't want.
Yes, I'll keep it in first week. Yes, next.
95.
My lord. Here, my lord. Petitioner challenging the order of London Session Judge cum Special Judge Rayagada, wherein the London Court below has rejected the 311 petition which was filed by the present petitioner for recalling of the victim girl for further examination, my lord. Here, my lord, now the present status I have filed, the affidavit has been filed by the informant of a victim.
You want PW7?
Yes, my lord.
What is the status?
Status is that now they both are residing as a husband and wife. That affidavit has also been filed by the informant victim. So she has no objection if the petition will be allowed. And
where is that? Where is that? No objection.
That is at
flag B.
Flags B and flag C, both.
Flag B.
Flag B.
Petition is agreed by the order dated. Petitioners or petitioner?
Petitioner, only one.
Here is an accused from. He is agreed by the order dated 25/11/2023, whereby the application under section 311 CRPC to recall PW7, the victim girl has been rejected by the trial court. Rejected by the trial court. Trial court, various grounds. On various grounds. He has challenged this. He has filed the present petition seeking recall of the state witness on the ground that the parties have settled their dispute. In the meantime, the party have settled their dispute. The notice was issued to the informed victim, and so and so entered appearance and has filed an affidavit dated Kamalini Pani, na?
Yes, ma'am.
Affidavit dated
Kamali Pani.
7/11/2024 inter alia stating as under 124. Okay, 124. In the said affidavit, she has stated that she had married with the petitioner, and so as to save her marriage and lead a peaceful conjugal life. She is ready and willing to depose before the court, before the court, if she is recalled. Essentially, she submits that the application moved by the petitioner under Section 300 CRPC may be allowed, and an opportunity shall be granted to her to depose before the court. Regard being head to the aforementioned particular circumstances, I am inclined to allow the present petition, and the trial court is accordingly directed to summon the PW7 for re-examination by fixing a particular date. It's made clear that the petitioner, either the petitioner or either the defense or the prosecution shall not seek unnecessary adjournment in this matter, and complete the cross-examination of the victim on the date to be fixed by the trial court. With this observation, the petition is disposed of. Yes. Any urgent matters which will be here? 103 is waiting for such a many times he has mentioned. 103. Adjournment don't mention, automatically it will be mentioned. Yes. 103. Yes, 103, what do you want, sir? You have been mentioning it.
The petitioner is a minor and student. He has not committed any offense and commission as alleged by the complainant. The affair story, they have stated 20 to 25% claim, and both.
What is the stage?
They are appearing before the juvenile justice and bail annexed to page 15.
But investigation is going on.
No.
Where is the charge sheet then?
Charge sheet has been filed on 5/7/2024. I have filed copy of the charge sheet.
Where is that?
Charge sheet, internal page 16, lordship mechanics. Internal page 16.
What is the urgency?
6 line.
You are on bail.
My lord, student and entire family is in place.
That's right, but you are on bail.
His carrier is, my lord, already disturbed, my lord. If he will in pressure, what will happen, my lord? Definitely a carrier of a student, and he is the future of the state, and he will lose all his.
If he is convicted, then only. If he is convicted, then only things will happen. Not now.
Family, father is a.
That's right, but where is the charge sheet you said?
Charge sheet 5/7/2024, at internal page 16.
16.
6 line 16, page 16.
16, huh?
Yes. Only 6 lines bottom. As a prima facie evidence is well made out against 3 accused persons and 1 CCL1 Pradeep Rigal, 19, son of Libin Rigal, road number 4, unity so and so, Kharawal Nagar, Bhubaneswar, district. 2. Shubham Naik, 19, so and so, Visoi, Kharwala, case number 103, Akash Gadai, son of so and so, Gadai, PS, Noyagod, CCL. Next come to Monmouth, aged about 17 to the scene, Satyanagar, near PS, no prima facie case in this case. And also no witness have whispered any word that Monmouth petitioner.
Where you have not filed any evidence, 161 statements.
Yes, my lord. 161.
What are the, have you filed the entire charge sheet?
Yes, yes. my lord.
Where are the statements?
Statement is at page 18.
Only one statement.
180, complainant.
There is nothing here.
Yes, my lord.
18 is the certificate. There is no 161 statement. You have not filed in a single statement. Nothing is there. If you want that no case is made out, I have to see the charge sheet, entire charge sheet.
Entire charge sheet is I have filed.
No, you have not filed. Just check it up. Check it. In my file, it is not there. It needs consideration. You are on page.
Nothing said against the petitioner that he has given a blow or a rod or anything.
You place all the document, at least let me examine that. None of the statement is there. Yes, urgent it for second. Yes. I thought it is very urgent.
May I please? 108.
Huh? 6, yes.
108 interim order may be extended after.
Wherever there is interim order, that will continue and the date will be given and the fresh matter urgent. Okay.
May I be permitted, Milords?
Yes.
Your Lordship remembers 117.
106
It's a POCSO matter where this interim order has been granted. POCSO, he promised to marry and the agreement that is on record. He was supposed to take instruction whether he will marry the girl or not. The girl is pregnant now; she has delivered a child. So he was only to give this statement whether he will marry or not. That is how from last week it was urgent to today. So
yes,
your Lordship may fix it.
I'll fix it. Interim order is there. Fix it. Interim order continue.
That is the only thing, my Lord, says short date.
The girl has to come.
No, girl, I am for the girl, my Lord. She doesn't want to marry. She has been defrauded. The boy has been asked to, lawyer concerned, was asked whether he want to marry or not. Otherwise, it will be dismissed. That is the reason it was fixed.
Who is appearing for the petitioner? 106?
117, my Lord.
Opposite party, it's a 138 matter.
No, not 130. 117. Sorry, 117.
176. I am saying that.
He is arguing 117. Anybody is appearing.
Oh, sorry.
117.
170.
Nobody.
Now that interim order is there, nobody will.
But there is no urgency. You have not filed the entire petition. Why are you wasting time?
Different copy has been filed.
This is not there. What to do? You want quashing of an FIR charge sheet without filing anything. On the basis of your oral statement, I'll record and quash it.
No, my lord.
307. Try to be reasonable to the court. And see, everybody is waiting. You file a complete petition at least. There is no government, nothing.
I have filed, sir.
You make some oral statement that quash it. 307.
Not we are saying this.
What is injury? Show me. Nothing is there. What kind of injury? What kind of weapon used by you?
Nothing. No weapon I have used.
Your nothing will not make nothing unless you show me the documents.
Write the document.
Then
It is not.
try to be reasonable to the court. Then one can exercise this.
Maybe pardon my lord. 110 your lordship had said while granting interim order or not, I'll let them appear. It's a case of I had given 2 checks as security subsequently.
He will spill over कर दियो 4 दिन पे जोड़ा urgent अच्छी आउ जोड़ा रे नहीं entry
My lord,
And also,
I want to mention my lord.
also your
one matter I kept it.
Your lordship had said also to refer the matter to mediation. It may be sent by your lordship. The
Who is appearing for this?
other side is appeared.
Who?
Santosh Kumar.
Call him.
Yes, my lord.
You are shall I send it
Lordship.
to mediation?
No, my lord. Lordship, this matter not settled between both the
Then why should you?
Lord said,
Present your lordship. No, Lordship, they have.
Then your lordship may hear the matter.
Here, interim order.
My lord,
Interim order was not there. Lordship had said the interim order can be granted only after the appeal.
Now, without hearing,
my
I
lord,
can't give it.
I beg your lordship's pardon.
Okay, my lord, first week let it be posted.
First week.
Item number 118, madam. Well, that matter, your lordship has already quashed the charges that 4 persons have approached your lordship in revision. And your lordship has that Supreme Court matter, my lord, tax matter, which was audit matter was Supreme Court has set aside that audit tax.
376B.
No. Well, PC Act, my lord. Your lordship referring to the Supreme Court judgment where the audit report and the demand notice was passed. Basing on that, your charge has been caused. This is the judgment passed by your lordship. And your lordship has put it to this, already condoned the delay. And this is one of the petitioner is one of the accused in that case, my lord. But unfortunately, he has not approached your lordship in those 4 revisions.
Who is appearing for the vigilance?
Vigilance. My lord, I have already sought that.
Who is appearing for the vigilance?
Mr. Sangram Das, my lord. Last occasion, my lord, he was also absent.
And he said that he will verify whether you are same accused in this FIR.
Yes, I am giving, my lord. The order which your lordship has set aside, I am the one of your lordship may have a glance to.
How many accused were there?
There are 5 accused persons, 6 accused persons against whom a case was abated. 5 approached your lordship in 5 revisions. My lord has quashed set aside that order. I am one of the accused, accused number 2.
Put it tomorrow. Huh? We'll see.
May I pardon?
I got a submission.
I'll pass the same order.
On the top of
May I
this, my lord.
I have got a submission of 53. Your lordship had, my lord, this interim order has been extended. This, my lord, operation case, item 53. May I pray for this copy of the order in course of the day?
If you leave me, I'll go and do it. I have a function also.
May I pardon? May I pardon to Mr. Wala?
It's not possible. If this is the manner things are to be done, it is not possible. Humanly not possible.
May I pardon to Mr. Wala?
And I have to correct also whatever they write.
Why I say, my lord, tomorrow is the
What to do is the systematic things as to see you file many of the cases.
In that event, let the state inform the IO.
I don't know why I can't.
I say that.
Yes. Item number 1.
I have already said by.
No, I am mentioning 111, my lord. Release of the vehicle, my lord. Last occasion, my lord was pleased to listen the matter and directed to only no.
Mr. Sanjay Das and Mr. Yena. 119? 119, na? Can it be done tomorrow?
Even my notes of commission, and senior friend, respected senior friend, has not filed the written notes of submissions. If he files, your lordship can visualize the same.
No, my lord, it's not necessary. I'll close it. I'll close the argument today and we'll file a written note. I'll take my lord cursorily to the facts. Okay,
I'll put it tomorrow and close it.
Yes.
Because the pressure will come on me. Then I'll have to read everything. That's the problem. I want to hear it and.
So many matters are there, and I have also got 7 rare matters, important matters.
Then 24th you give some time. 24th.
It is there available in the. I have filed e-filing as well as in the.
Everything is available. I want to get the time to read it. That's the problem. But it is very.
Nothing is going to be necessary, my lord. It will be, my lord can.
No, I am just struggling on one thing. None of you has given the affidavit, judgment. The only thing is, after the conviction, can I revert back to the case diary, ignoring the evidence?
No, my lord. Case diary was called for some other reason. My lord, that's very
your case. The entire case is revolving on that case diary.
Yes.
Can I look into that?
That, my lord.
After conviction in appeal proceeding.
No, my lord.
That's the judgment I wanted.
My lord, that judgment, my lord, I can give it, my lord. I'll be prepared tomorrow also if my lord, I'll give it to my lord. And in the course of the day, I'll.
You please give that judgment. That is where I am struggling.
No, my lord. If it is the first point that I was arguing regarding the sanction, this is where that arose. But if regarding sanction, if I am supposed to.
To that extent, he has pointed out, the sanctioning officer said that everything on date I placed it.
The sanctioning authority has to be appointed by the government.
That is the second point.
That is
the second point.
That is the first point, my lord. My lord, the most important aspect about this
at page 102, what has been written, my lord, is that I had earlier stated on X date